Any mention?
My lord, joint request with regard to item number 5 and 6, my lord. Yes. My lord, this is a matter which is still pending before the Supreme Court, my lord. 5 and 6.
This will be dependent upon the outcome of the. This will be
Yes, my
dependent on
lord. The outcome is awaited, my lord.
This has been recorded before also.
My lord, yes. There has been multiple orders, my lord, in which we have made submission, and there are orders also, my lord.
Then when do you want it then?
My lord, may I have this matter after 3 or 4 weeks, my lord?
Just check the last order, just see if it's pending or things. After
4 weeks, my lord.
5 and 6.
My lord, 5 and 6.
Okay, responded. Yes.
My lord, I beg to further mention item number 19 and 20, my lord. And for the state respondents. (19 and 20).
Yes.
My lord, this is a 482 application, my lord.
After 2 weeks. No problem. When do you want it?
My lord, 2 weeks.
You are appealing for the state response.
My lord, and for the state.
Okay. This one permit. MS County, knowledge G. The state response list after 2 weeks. This 19 and 20. Yes. Obliged.
Please, Lordship.
Yes.
I'd like to mention item number 15, Lordship. Can you allow us 2 weeks' time, Lordship, for hearing?
Yes.
Your Lordship, I have no objection.
No. This is 15 2 weeks. Mr. Petition. Yes.
Obliged.
Yes.
Please, Your Lordship. Your Lordship, I'd like to mention item number 16, Your Lordship. On behalf of the respondent number 2.
Yes, what happened?
16.
Yes. You are appearing for?
For respondent number 2, Your Lordship.
Yes.
Leading counsel was supposed to appear through VC, however, he's not able to obtain the VC link.
Who is the leading counsel?
Mr. Paul Pascal, Your Lordship.
Yes.
Lordship, it has been done on number of occasions.
What is to be done
So,
if he is not there?
let us fix
You
on
can
that.
understand, but then would you like to get an order in absence of the?
There's no urgency also, as a matter of fact.
Urgency is there for you, it may not.
We'll have it then after a
Next
week.
week.
After a week.
Yes, Your
After a
Lordship.
week.
I'm appearing on behalf of the state response.
Yes, just one prayer. Just number so and so. Just after a week.
Item,
Yes.
item 18. We made a joint request on the last occasion that if the matter can be upgraded, Your Lordship has.
Is there any need of doing so? There are very few methods.
There will come up, Lordship.
After the order.
Okay, any other matters? Okay, we can. Okay, you just call this item 17 as first item in the hearing. After orders, you first call item number 18. Yes.
May I please, Your Lordship? I beg to mention item number 17. My lord, a similar matter is pending before the division bench, my lord.
Item number 17.
Yes, my lord.
This pending before division bench.
Yes, my lord.
It's after 3 weeks.
They'll come after 4 weeks, Your Lordship.
17. 4 weeks. Yes.
Apply, Your Lordship.
May please, Your Lordship. Your Lordship, I beg to mention urgent listing, a criminal revision. So, in this case, the CBI court partly discharged me. So I filed this criminal revision petition. So I for listing tomorrow. If
It's a new filing, new matter.
in new matter, yes, Your Lordship.
What is the urgency?
Urgency is that day after tomorrow, the London Court CBI will list for framing of charge. So we.
When the order was passed?
The order was passed on the 6th August.
So you are filing, you have come approach this court. It's a delayed approach. Anyway, just we'll just see it tomorrow.
Tomorrow,
You
yes.
filed it.
Yes, yes. We are in the process of filing. Much obliged.
Your Lordship, I beg to mention item number 11, Your Lordship. The conducting counsel for the petitioner is on sanction leave.
Yes, who is appearing for the?
State, Your Lordship. 11.
Yes,
No objection, Your Lordship.
this is also quashing application
Yes.
pending from 23. Okay, 11 also on prayer petition list after.
2 weeks, Your Lordship.
Yes. Yes.
No
Right, Your
objection.
Lordship.
May I please, Lordship, I beg to mention item number 7, Your Lordship.
Item 7.
Yes, Lordship. If the matter may come up after 1 week, Your Lordship.
We'll have it after 2 weeks, madam.
This is also a criminal appeal of 2022. Perhaps this is the only appeal of 2022 which is pending now.
Yes.
Before the single bench, there is no other appeal which is older than this. Yes, 22 on the prayer made on behalf of the appellant, list after 2 weeks. Yes.
Much obliged.
Wait, please, Your Lordship. Lordship, I beg to make a mention for item 13.
Item
13, Your Lordship.
13.
Lordship.
Yes.
Lordship, similar matters pending before division bench, Your Lordship. 13 and 14, Your Lordship.
13, 14.
Lordship.
Both are same connected to this.
Lordship.
Okay. After 4 weeks.
3 weeks, Lordship.
Okay, after 4 weeks.
Deeply obliged.
Highly obliged, Lordship.
Item number 1.
Yes.
Wait, please, Your Lordship. Lordship, we are entering our appearance today on behalf of the sole respondent. And my lord, there have been some developments in this matter, if Lordship allows. What has happened is that the petitioner number 1,
What is the matter about? What is
matter concerns, it's essentially a property dispute between relations, between relatives. Property situated in somewhere in jail room, my lord. So dispute is pending in the trial court, in the lower court. Now, development is, my lord, that petitioner number 1 has sent his well-wishers, etc., to the respondent to explore the possibility of trying to settle this matter. So, respondent has expressed her willingness to do so. If Lordship allows, if this Honourable Court allows, maybe mediation could be one way of settling this dispute.
We agree, my lord. It can be sent for
You
mediation.
want this matter to be referred to justice?
Because it's a family dispute, so it's better to refer to mediation.
My only prayer is that in the meanwhile, the interim order may kindly be extended, my lord.
Can you just say, Mr. Jindal, Governor Council has entered appearance on behalf of the. There is only one respondent.
One
Only
respondent.
sole respondent. And hence the service is complete. Stop. Then you say. Governor Council, next paragraph, this is Governor Council appealing for the parties submit that intervention of a mediator in this matter may help the parties to come to amicable settlement. Come to an amicable settlement. In view of the submission, that this matter be referred to the High Court Mediation Committee for doing the appeal.
Obliged.
Okay, then just say, in the meanwhile, the interim order past earlier shall continue.
Much
Obliged.
obliged.
Item number 2.
Yes.
We have filed our affidavit, Your
affidavit?
Lordship, to bring on record the statements of the BSF persons.
If Lordship may see the last order, submission was that the charge sheet brought on record by the petitioner was not the complete charge sheet.
Oh, that is that foreigners issue.
Lordship.
Yes.
But the affidavit which they have filed, admittedly the charge sheet does not have any statement of any person, Lordship, apart from the two accused.
Lordship,
Now they have got statements on the CD and put it here. Otherwise, I am not entitled to see the CD also, Lordship.
Okay.
So that is the
So
position.
there was no purpose basically.
No purpose, Lordship.
Where is that affidavit filed by?
this is the affidavit, Your Lordship.
Filed on 5th.
On the 5th, we have filed it. 5th of September. 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 5 We have filed this, Your Lordship, on the as per Section 193 of the BNSS Act.
What is that 193 of VNS Act?
193
is
states.
final form, Lordship.
Okay, so
Filing of
that
charge.
is one.
And then, Your
173
Lordship,
only.
the names of these BSF persons have also been cited as witnesses in the charge sheet that was submitted by the petitioner. The BSF persons have been cited as witnesses,
Where
state
is-
witnesses.
Where is that list of witnesses?
The list of witnesses.
So they're in there.
At page 14, Your Lordship.
Of your affidavit?
Or 12, yes, 12.
Of their
Of your affidavit.
Lordships.
Of their affidavit, Your Lord. These are the BSF personnels who have been cited as witnesses. And the statements had been recorded by the IO, but it was not enclosed with the charge sheet, which is why we sought permission from this
This
honorable.
list of witnesses there in your charge sheet?
Yes, Your Lordship, it is there.
So essentially there is no difference, isn't it?
Lordship, yes. Because
Only
even
accept-
in the body of the charge sheet, there's nothing mentioned about the statements of the complainant.
Only documents are those statement of
13.
And
the
some of
13.
the photographs which we have attached with our charge sheet and which the IO had submitted
Where is
were
the
not
list-
attached.
Where is the list of documents or evidence in the charge sheet?
Lordship,
Where it is?
Page 14, Lordship,
Page 14 of the same affidavit.
of the same affidavit.
This affidavit is there.
So 13 documents.
What relevance those documents have? The photographs have?
The IDs.
These are the IDs.
The IDs and their, yeah, and the birth certificates, etc. were not
These are not
attached.
disputed documents, isn't it? This has no bearing. The charge is very limited, that they have violated the
Yes, Your
condition
Lordship.
of the visa.
Visa and they
Entered
have
Bangladesh,
crossed, you went to Bangladesh and crossed over from Bangladesh to India, Your Lordship.
If I may, Lordship, charge is not that they have violated the visa. Charge is that they have illegally entered India.
No, that is not correct. Illegally entered India from Bangladesh, Your Lordship. That was not the entry route for them.
where is the charge sheet? Charge.
Page 14 only, Lordship, right on top. Based on the above facts and circumstance, it is found that the prima facie case under 14A of Foreigners Act is well established against the accused person mentioned below for crossing over to India from Bangladesh illegally through unfenced
Unfenced
international border.
detail. That was not the entry point, Your Lordship.
Page
Where
14.
is the list
Page
of
14,
witnesses?
Lordship, just above the
Oh,
enclosures.
this is the, which they had submitted. It was is this the one?
For crossing over to India from Bangladesh.
Which part you were reading?
Right on top, Lordship. Based on the above facts and circumstance,
Yes.
it is found that prima facie case under section 14 capital A of Foreigners Act is well established against the arrested accused person mentioned below for crossing over to India from Bangladesh illegally through unfenced international border. It is not a case of violation of visa, Lordship. Violation of visa anyway does not come under 14A.
The violation of visa comes under what section?
Violation of visa is, Lordship, 14 small b, that condition of visa.
Not,
is.
not 14A.
No, Lordship.
14A, Lordships, clearly states that enters into any area in India which is restricted for his entry
Yes.
under any order made under this Act or any direction given in pursuance thereof.
Where there is a specific restriction there.
They,
That
Your
has to be
Lordship,
explicit.
they have the very fact that they have crossed over to Bangladesh, Your Lordship, and then re-entered India through an unmarked or
Where is that they crossed over to Bangladesh?
that, Your Lordship, we have it is in the FIR, Your Lordship.
But there's nothing in the charge sheet, isn't it?
In the charge sheet also,
It is there mentioned, Lordship, in the First part.
In the charge sheet also it is
From my
clearly
statement there.
stating, Lordship, that it is well established against the arrested accused persons mentioned below for crossing over to India from Bangladesh illegally through unfenced international border, Your Lordship. And this, they have been arrested on the basis of an intelligence report which they have received, Your Lordship. The BSF personnel who were manning the border received intelligence report, and on the basis of that, they have arrested these people. The passport which these people were holding was also had clearly restricted them from entering into Bangladesh, Your Lordship.
They are crossing over to Bangladesh from India, not their return. Only if it is crossing over, will it be a violation of Indian law?
I have not understood, Your Lordship.
Say supposing a person who enters India and crosses over to Bangladesh.
But if they have crossed over to Bangladesh through an unfenced
will it
border,
be
Your Lordship.
just if it is crossing over, that means their departure is not after taking due permission.
Due permission from
Isn't
the
it?
country.
So, will it be an offence under
Yes,
the
Your
Indian
Lordship.
Foreign Indian
Yes, Your
Foreigners
Lordship.
Act?
Cannot be, Lordship. In the
Their entry into India was permitted.
I went over to Bangladesh.
Yes, both of you speak together, then we will not lose.
Assuming a situation, Lordship, where they entered to Bangladesh without from the unauthorized checkpoint or otherwise, and they didn't come back to India. Say they left. India government would not have anything to prosecute, Lordship.
Of course, if they are not caught, there is no
There-
question
there
of
is no-
prosecution. But the thing
And
is
if
that
they are
whether
caught in some
that
other
will be
country,
a violation of Indian law or not.
That will be a violation of the UK passport or the refugee.
But then what happens if departure rule is violated?
Because 14A talks about only enters into, does not say departs India, Lordship. Enters or stays. So if someone goes outside,
The FIR in the charge
even
sheet is
without a
because
visa,
of that.
say someone just goes out to some other country, Lordship, by changing his identity or any other way. I don't see, Lordship, how the Foreigners Act will come into play in that situation. In my understanding, Lordship.
They are foreigners is not disputed, Your Lordship, as far as India is concerned, Your Lordship.
There is, we are not in that
Yes.
thing. So
No, that
why,
is what.
That
So-
is why you see, burden of proof is not specifically on.
Yes, Your Lordship. Now, the very fact that they have violated even the passport, British passport, which they were holding, on the basis of which the visa was given by the Indian government, that has been violated, Your Lordship. They entered into Bangladesh. Now, Your Lordship has been repeatedly
Now
asking
this-
me.
Who puts that condition in the visa?
No,
Who put? Which nation?
the passport had restricted them from entering into Bangladesh, Your Lordship.
That is okay.
On the basis of that
Now, this
passport, Your
passport
Lordship.
was not issued by Indian government, isn't it?
Passport was not issued, but on the basis of that passport, Your Lordship, Indian government has issued the visa.
So that will also constitute a offence.
Because it emanates from
where
that
it is, Where it is
passport.
provided that? Where
It
is
emanates
the
from
law?
the passport. The visa
Where is
has.
the law? Just give me a foreigner. Just point out those things. Let us just see.
The Passport Act is not there. You had given me a Passport Act. Yeah. It means passport was not there.
Where is the provision relating to departure from the country?
There is no provision, Lordship, in the Act.
For
How
departure?
can that?
I don't see.
Departure and entries from designated areas, Your Lordship, for foreigners, Your Lordship. They cannot come in and go out at their will, Your Lordship, from
That is
any
what-
point.
That is what.
Yes.
Say supposing if departure, basically a person, a foreigner leaves the place before his original date of departure, which has been recorded at the time of registration. Then what happens?
Then, Your Lordship, they'll have to get permission and leave through the same place where they have, which has been designated, Your Lordship.
where do we get that provision for departure and all? Where is that?
Their visa is also single entry. It do not permit their re-entry.
Into another country.
The offence here is that they re-entered
India.
through Bangladesh. Not that they went there. Their re-entry into India from Bangladesh.
Then, Your Lordship, in the passport rules, Your Lordship, of 1950, 5.4 clearly says that they had their visa was a single entry visa. That means they had no right to come enter India again from Bangladesh, Your Lordship. The visa may kindly be perused, Your Lordship. It was a single entry visa.
This is rules 1950. Now this rule has been framed under what provision of law? It's very difficult to read.
Yes, Your Lordship, it's not very legible. Here's the visa.
Under what provision of law this rule has been framed? For section 3 of the passport entry into India Act.
Passport entry
So
into
that
India
is,
Act
it has nothing to
1920.
do with Foreigners Act. Now whether this offence is prescribed in the Passport Act or in the Foreigners Act.
It is in the passport rules which says that when issued.
See, this passport rule has been framed under the Passport Act, not
Yes,
the
Your
Foreigners
Lordship. Yes, Your Lordship.
Now, say, let us assume that there is a violation of rules framed under the Passport Act. Now, whether that will fall under the offence of whether it will come under offence.
The very fact that they have violated the visa, Your Lordship, there was a single entry
Now,
visa.
right now we are dealing with Foreigners Act, isn't it?
But we are dealing with Foreigners Act because these people are foreigners, Your Lordship. And because they were foreigners, they had a visa to enter India.
See, madam, whether Passport Act has any provision for offence.
Passport Act maybe have. We are only dealing with.
Whether violation of any of the rules, that passport entry rules, will constitute an offence on the Foreigners Act or on the Passport Act.
These are the conditions of a valid passport, Your Lordship.
I can understand. The question is that whether it will constitute offence under what act?
Must be under the.
Yes. You want to say anything? So what is to be done? You took so long for you to say that. We have almost finished the hearing. He has anything to say here? Then we'll have to wait for some time then.
Okay, Your Lordship. In the meantime, I'll just examine this passport.
Just see, these are queries coming to mind, may not be very relevant for
It may
deciding
not
this case
be.
also.
But then I had
But then-
also
But then the
relied
court
on
must,
some
the court
authorities, Your Lordship.
must have a clear understanding. That is the
Whether
main.
the court can. Anyway, I'll make my submission later.
When your visa is going to expire?
11th, Lordship, for the first item. 11th.
And today is
Today is
8th.
8th, Lordship.
How can
Actually, they've come at the fag end, Your Lordship.
I
They
came
were
in for
released.
July, Lordship.
They were
I
released
had
in
approached the
July.
court in July
They were
itself.
released in July, and they have filed this petition in the end of August.
I filed it on 31st July, Lordship. 3 weeks was given for the state to take instructions. Then, Lordship, on Monday, unfortunately, the bench did not sit. Then I moved an unlisted matter to have it last Monday. Then 2 occasions they wanted to
So
file
what
it.
happens in such a situation if this matter cannot be completed?
Lordship, I have seen, I don't really know under which provision, but I have seen that High Court can, Lordship, regulate, or like regularize that. I have seen
I
certain
think
parts.
if there is a criminal proceeding pending also,
Yes.
that is there, just somewhere.
Yes, it is
issues
there,
are
Your
there,
Lordship. One authority I've got of Delhi High Court, Your Lordship,
They
which
say that
There
immigration
may be
can-
somewhere in some
that
enactment.
Your Lordship can direct the competent authority
that
of
is
the
okay.
Ministry of Home Affairs
There may be, that provision may be there.
to extend the visa or to so that they can face the trial here.
This act is of 1946. Now this Registration of Foreigners Act 1939. Just see, there may be some provision.
Let's see the act. They might have, I mean, the authority, they might have mentioned it.
No, not there. Then what about? No, this is there somewhere.
Some judgments I had just come across that where the immigration authorities have been directed to just.
Yeah.
There is some provision regarding departure. This court doesn't remember right now. There it is provided somewhere regarding pendency of criminal case.
We'll just look into it, Lordship.
This, I don't know if this is the correct. Further, in respect of a foreign national against whom one or more cases are pending, it is submitted that as per Section 5(2)(c) of the Foreigners Order 1948, foreigners' presence is required in India to answer a criminal charge. Then I think there can be.
Isn't it? There is some provision,
Yes,
enabling provision.
under the rules.
You are reading out? You are reading out what?
The rules, Your Lordship.
Okay, rules of, under what rules?
Under the Foreigners Order 1948, Your Lordship.
Okay.
Three two C.
This para, which para you are reading?
Option, this is the Foreigners Order 1948.
Which para? It is different paragraphs.
Number
The paragraph number?
Number 5, Your Lordship.
0.5.
Here, this is a case of. I'll just submit this authority.
Okay, power to grant permission to depart from India, isn't it?
Departure.
We have that. This is, we have it.
Yes. No, I'm giving the authority. Delhi High Court has directed
That is
me.
okay. Anyway, let us just see it. We just wait for Dr. Mojika. Dr. Mojika comes. Yes. At the end of the board.
Hearing, item number 18.
Yes. That is regarding that execution.
Yes, Lordship. Lordship.
Yes. Yes. Yes.
On the last occasion, Your Lordship, I have prepared a bullet points and I have served the copy to him, but a copy was given to the bench assistant also. And since there was no order to that effect, so it was returned to me. I am again submitting, Your Lordship.
Okay.
That will make the things a little easier. Your Lordship, this is an application under Article 227 of the Constitution of India, which arises from the order dated 5/2/25, passed by the Commercial Court in an execution proceedings, Your Lordship. Now, by this order, the learned Commercial Court has accepted the calculation which was made by the decree holder and rejected the calculation which was furnished by the judgment debtor. Your Lordship.
So what requires is that we should determine what is the correct.
What is the correct. And because for that law is laid down.
Okay, just tell us one thing. Like so far as the arbitral award is concerned.
Yes, Lordship.
Now this is something like a decree of a civil court, isn't it? So far as the
it is deemed
execution.
to be a decree for the purpose of execution.
Okay. So that is what we need.
Yes.
Because executing court cannot go beyond the decree.
That is a settled law.
So
that is a settled law, but Your Lordship, in this arbitration matter, I would point out the judgment of the two judgment of the apex court, wherein when there is a question of the post-award interest, and the post-award interest, even if the arbitrator have not awarded and are silent on that post-award interest, then even the post-award interest is not mentioned in the arbitral award, still executing court has the power to grant post-award interest, unless it is.
Now whether that will be granted by the executing court?
Executing court, because slab is fixed 18%. 18%. If the arbitrator exercises its jurisdiction under clause B and award a interest less than 18% or decline to award interest, post-award interest, the dispute is only about the post-award interest. Pre-award interest, there is no dispute. Post-award interest. If the arbitrator gives the post-award interest on a particular sum and does not award the interest on the remaining, that clause B cannot be enforced in that case. But if the arbitrator totally ignores clause B of section 31 and is silent about that post-award interest, then the executing court can grant the post-award interest, because this is
granted by the statute.
By the statute. It is by the statute, and it is not subject to any agreement between the parties. Parties cannot enter into an agreement taking away the provision of clause B.
That is subtle thing.
Settled
if
law.
you say something,
yes,
the agreement cannot lay down something else otherwise.
Otherwise. But so far clause A is concerned, pre-award interest, parties can lay down.
Here we are not dealing with that part. Pre-award.
We are not dealing with the pre-award interest. Your Lordship will just see first page 307.
Just a minute, Mr. Jindal. I will just take You will go a bit slow and make the court understand. The court
I'll
doesn't
go
understand.
slow, Your Lordship. I'll go slow.
Yes.
Very, very slow.
At least make sure the court understands what.
Yes, Lordship. This is the Your Lordship calculation which has been
30?
submitted.
Page 30?
307.
Is it? It is not reflected in the impugned order of the
It
executive
is
court.
reflected.
So why don't you refer it from the order? Then that will become things will become easy for us. Instead of traveling here there, let us just see.
Yes, Lordship. Page number 293. No, I'm sorry, Your Lordship, not
Page?
293.
My lord, 319.
319.
The impugned order.
Impugned order.
Just before that, can we see the award? That
Yes,
relevant
Lordship.
part of the award.
Let's see the award.
I think it is page 68.
68. Your Lordship, may I read?
Yes, yes, please. Just yes. Yes, please.
Accordingly, we, Shri A.K. Mitra, presiding arbitrator, Shri A. Bark Kataki, member arbitrator, and Shri P.K. Biswas, member arbitrator of the arbitral tribunal constituted for the resolution of contractual disputes between Messrs. Mega Electrical and Shri Rajkumar Das joint venture, JV stands for joint venture, claimants, and Messrs. Power Grid Corporation of India Limited in respect of contract agreement number so-and-so pertaining to the construction of pile foundation at location number 2 of 400 kV DC Ranganadi Balipara line under O&M hereby unanimously award a sum of rupees 1 crore 31 lakhs 87,889.00 in favor of the claimant and direct the respondent shall pay the same to the claimant in full and final settlement of all disputes and claim before us for adjudication under the present reference. We also award and direct that the respondent shall pay simple interest at the rate of 12% per annum on the awarded amount of rupees 1 crore 26 lakhs against claim number 1, 2, 3, 4, 5 and 6 and on awarded amount of rupees 5 lakhs 32,096 against claim number 7 from 5/7/2013 and 21/3/2015 respectively, being the dates of submission of SOC stands for Statement of Claim. For claim number 1 to 6 and claim number 7, till the date of payment of the awarded amount by the respondent to the claimant within 19 days of the receipt of this award, this rate of simple interest at the rate of 12% per annum would however increase at the rate of 2% per annum subject to a maximum of overall simple interest of 18% per annum for every quarter of delay, if any, made by the respondent in releasing payment of the awarded amount beyond this stipulated period of 90 days mentioned above. award made, signed and published on 30th day of December 2016. 2016. No, about 9 years have passed here.
So as per
Now-
the award,
Yes.
see, they were to pay 12% interest per annum on a sum of 1 crore 26 lakh something. That is effective from the date from 5/7/2013.
And for
other is effective from 21/3/2015
Yes,
till the
Lordship.
date of realization.
There were total 7 claims awarded by the tribunal. So far, claim number 1 to 6 is concerned, they awarded 1.26 plus, and with regard to the claim number 7, they awarded 5.32. So far, the simple interest of 12% is concerned, the tribunal has taken a different date of starting point
Yes.
of the interest.
Yes.
But conclusion that the interest will be paid within that amount will be paid within 3 months from the date of the publication of the award, and if not paid by interval, it will reach up to 18%. 18%. Your Lordship, first of all, I have no dispute that the tribunal has awarded only the simple interest. I have no dispute on this point. And I have also no and there is also seems to be no dispute that simple interest of 12% is awarded on the entire sum prior to the award. And the difference between pre-award and post-award is this, that so far post-award is concerned, if the amount is not paid, then it will carry further interest at a certain interval, maximum up to 12%. 18%.
That is what has been stipulated here, that
Yes.
if the payment is not made within 90 days,
Yes.
there will
No,
be further enhancement of 2% per quarter, but subject to 18%.
18%. Here, Your Lordship, what I am trying to say is that the difference between pre-award and the post-award is this. So far, percentage of 12% is concerned. The difference between pre-award and post-award is this, that so far post-award is concerned, it will vary after 1 quarter, subject to the maximum of 18%.
So far as the pre-award amount is concerned, this will be intact.
This will be intact.
12%. It will not go.
12%.
It will not go enhanced.
Even
if it is not paid within 90 days.
90 days, if it is not paid 90 days after the receipt of the award, then the entire awarded amount will carry interest at the rate of to the maximum rate of interest of 18%. Your Lordship, here the main point of controversy is the use of the word amount awarded. What does the amount awarded? See, I have no dispute with regard to the percentage of interest, that it is 12% and 18% in the case of post-award interest. Neither my friend is disputing so far these facts are concerns. The dispute basically lies upon what does the awarded amount means under the impute award. Whether my friend's case is this, that the tribunal has awarded interest on the principal amount, and the decree holder and the court below, commercial court, has calculated the post-award interest on both interest plus the principal amount so far the pre-award is concerned. Pre-award, your lordship, has got two components. They are
So far as this decree, your award is concerned,
lordship.
what is the amount of pre-award?
Pre-award amount is 1 crore 26 lakhs 55,793. This is with regard to claim number 1 to 6.
Now, the pre-award and post-award is a term normally comes for awarding interest, isn't it?
Yes, lordship.
Award remains award.
No, this comes normally with the interest, awarding interest. Here, your lordship, so far the arbitration is concerned. Now, I'll take to your lordship, what was the previous law which has been changed? Unless your lordship knows that what was the law prevailing prior to this 1996 Act, when section 31(7)(a) and 31(7)(b) were incorporated. The matter cannot be easily understood. Now, so far award is concerned, the operating portion of award is concerned, my main contention is this, that the tribunal has nowhere used the word principal amount. Nowhere.
What is the meaning of the use of the word
amount?
Hereby unanimously award a sum of rupees so and so.
Yes.
Now, is it not that is the everything what has been awarded? Nothing beyond it.
Yes, your lordship, nothing beyond. Interest component is there.
That is okay, that is separate.
No, interest,
but so far as the awarded amount is concerned,
awarded amount, this is your lordship, awarded amount will as per the judgment, awarded amount will include aggregate of principal plus interest for the purpose of calculating the post-award interest. For the purpose of calculating, that is what the change has been introduced from the past. Otherwise, they would have used the word, the principal, with that tribunal awards 12% interest on the principal amount. Now, they have not used the word principal amount, where the legislature intended that interest should be paid only on the principal amount. The legislature has done it so in other acts. If your lordship take section 34 of CPC, section 34 of CPC,
yes,
section 34 of
interest.
Interest, where and in so far as a decree is for the payment of money, the court may in the decree order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged, your lordship. Now, where the legislature wanted that interest should be on the principal sum, they have provided there. And in section 31, your lordship, 7A and 7B, there is no use of the word principal amount. And so also in the operating portion of the award, your lordship will find the tribunal has not used the word principal amount, that 12% interest on the principal amount. They have said it. Now, Your Lordship, say for example, there is no delay in making payment. What amount will be paid by the judgment debtor? Principal plus the interest accrued thereon. It's not that first it will be separated. The total amount or the amount, total amount which will be paid, that will be interest plus the principal amount. Now, further delay in the interest, according to my learned friend, that further delay in making payment of the awarded amount, the interest will be charged only on the principal amount. What about the interest component which has been already awarded? On that there will be no interest. That money is with whom? Money is with the judgment debtor. It is otherwise illogical. Say for example, on a particular date the award is...
What is then which way we differentiate simple interest and compound interest?
Lordship?
Which way we differentiate simple interest and compound interest? Now, is it not that when we say simple interest,
Lordship,
the interest is kept on adding on the principal sum?
Yes.
Now, compound interest is something where...
No, Your Lordship, this is not awarding of the compound interest. What is being done is not awarding the compound interest. Here the requirement of the law is this. Clause B says that the post-award interest
one of you go, you can go one of you.
Let me also read Your Lordship Clause A
of Section
31(7).
Yes.
Unless otherwise agreed by the parties. Your Lordship, the opening words of Clause A provides autonomy of the parties. That parties have the autonomy to go beyond what is provided in A. Unless otherwise agreed by the parties, where and in so far as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. Here, Your Lordship, nowhere it is mentioned that it is on principal. What the word is used? Sum. Now, what is the meaning of the sum? Your Lordship, I will be taking Lordship to the Hyder construction case. That how sum is not interpreted as the principal. It is the total sum, which is inclusive of the interest as well as the principal. Otherwise, like in section 34, your lordship will compare section 34 here for a while, where your lordship section 34 is
Yes.
where and in so far as the decree is for the payment of money. Here also your lordship will find where and in clause 7a, where and in so far as an arbitral award is for the payment of money. Here also your lordship will find is for payment of money. The court may, in the decree, order interest at such rate as the court deems reasonable to be paid on the principal sum. Here sum is qualified with the word principal.
Now,
And here in section 31(7)(a), the word sum is not qualified.
what is principal sum then? Principal, what is meant by principal sum?
Joint meaning of principal sum. That your lordship, I'll take Hyder construction. Let us first see the factual aspect of this matter. Then your lordship,
You were at section 31(7)(a).
31?
7a. You were on that.
Yes, lordship.
Yes.
31(7)(a).
Yes. You have completed reading 7a.
Yes. Then your lordship come to B. A sum directed to be paid. Here again your lordship, the word sum comes. It doesn't come principal amount. A sum directed to be paid by an arbitral award shall, unless the award otherwise direct, carry intent. Here, unless the award otherwise direct, you means your lordship that 18% is the cap, and arbitrator has the power to bring it down to 9%, 6%, whatever.
But then so far as your case is concerned, 80% is the cap. That is what
18%. Beyond 18% they cannot go. Carry interest at the rate of 2% higher than the current rate of interest prevalent on the date of award, from the date of award to the date of payment. Here, lordship, this occurs under the prior to the amendment. Your lordship will see 31(7), which is a book where
Mr. Jindal, we do not have any dispute with regard to the interest and all those.
we don't have any dispute.
Yes.
So your lordship dispute is, I was trying to take to your page number 307 and 318.
Yes, please. Let us come to that. Just let us come to that dispute first.
Three 307, your lordship.
Yes.
307. No, amount payable with interest as on 16/7/24 as per the arbitral award dated so between Messrs. This is by the power grid. Total claim 1 to 6 plus claim number 7. Now up to claim 1 to 6, tribunal has awarded 1.26 CR. Let's take around 1.26. Against claim number 7, they have awarded 5,32,096.
You are reading which part of it?
No, the amount awarded amount, claim
Yes.
1 to 6.
Yes.
It is 1,26 lakhs.
No, you are reading page 307, isn't it?
307.
On the top, you are starting from the top, isn't it?
Yes, I started from the top.
Okay, award amount came out to 6. Yes.
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 Awarded amount on claim number 1 to 6, it is 1 crore 26 lakhs 55,793 with regard to claim number 1 to 6.
Yes.
Then for 7, it is 5 lakhs 32,096.
Yes.
And the total amount towards these 7 claims is 1 crore 31 lakhs.
What is that A signifies?
This is A for their ED reference they have made, because this is
Nothing relevant. It has no relevance.
no relevancy otherwise, just to identify total sum A. And here A means 1 crore 31 lakhs. Then interest, Your Lordship. Effective date as per, they have calculated the interest in two components. Pre-awarded interest on claim number 1 to 6, effective date as per award. The tribunal has awarded with effect from 5/7/2013. Date of award 30/12/2016. Now interest as per award 12% from 5/7/2013 to 30/12/2016. 1,275 days. Total interest is 53 lakhs 00870.23. This is for claim number 1 to 6. For claim number 1 to 6, the pre-award interest is 5 lakhs 30,000.
That is their calculation.
Their calculation. I am not disputing. This is correct. This is correct. Then the pre-award interest on claim number 7, effective date as per award is 21/3/2015, date of award 30/12/2016. Interest at the rate of 12% from so and so date to 650 days. It comes to 1,13,708.19. Then total pre-award interest on claim number 1 to 6 and 7, that is 54 lakhs 14,578.42. Now, if your lordship, the total interest is 54 lakhs 14,000, and total award amount is 1 crore 31 lakhs, and if it is added with the principal with the principal amount, then it becomes 1 crore 86 lakhs. Here I have given on, if your lordship see my calculation also, 3.
So far as this calculation is concerned,
There is no dispute.
no dispute.
No dispute, your lordship. My learned friend has rightly calculated so far the pre-award position is concerned. He has shown the principal amount at one place and the interest on the other place. Total interest on claim number 1 to 7. Your lordship. Then your lordship will see my calculation. Page number 318.
What is the subsequent part of the thing? Of that 307?
307, your lordship, I will complete. Just let me show your lordship my calculation on this point. Page 318.
318.
318. Only the thing, my learned friend has not given the total of principal plus interest, which I am showing, same figures. Total claim on the date of award, that is 30/12/2016, A plus B, comes to 1 crore 86 lakhs 02,467.42. This is the awarded amount This is the awarded amount.
This
1 crore 86 lakhs 02,467.42.
That is a total claim on the award, isn't it?
Yes, Lordship.
On the date of award. So total claim on the date of award.
Pre-award interest. That is pre-award interest. Now, it is same as of power grid.
Yes.
Only the thing, the total they have not shown, but if both the are total, it becomes 1 crore 86 lakhs.
Okay.
Now, the dispute starts from this point. From this point. For calculating the post-award interest, the two calculation has to be made. Now, a interim payment was made on 27/8/2019, and that payment was of 32 lakhs 96,972.25. Now, this payment, Your Lordship, was made on on 27/8/2019, date of award 32,000, and the balance outstanding was so and so. Now, Your Lordship, after passing of the award, the interim payment was made, and what they have not taken into consideration, that this amount which they have deposited in interim also would have carried the interest from the date of award. Now, award is passed, say for example today, of X amount. Now, out of X amount A, they deposit after 1 year. Now, for the period of 1 year, that amount A will also carry the interest. Am I clear, Lordship?
Yes, you can understand.
And which part they have not taken into consideration.
Now, according to you,
Lordship,
that pre-award interest gets included with the term award.
Award.
Isn't it?
And that is what
that is the sum.
That is what
and the
is
difference
sum.
of principal sum and sum lies there.
Yes.
Now, the amount
yes,
without pre-award interest is the
Lordship.
principal sum.
Without pre-award interest
Is the
is
principal
the
sum.
principal amount.
Yes.
Is the
The
principal.
moment this pre-award interest is included, it becomes the sum which is awarded.
Which is awarded.
And then
And the,
they have to pay further interest
yes,
in terms of the award till they make the payment.
make the payment. That is as simple.
That is your interpretation.
That is my interpretation. And furthermore, Your Lordship, with regard to the payment of interim award. Now, interim award is not that immediately it is paid on the date of award. Date of award they challenge under Section 34. Under Section 34. 34 first is filed at Guwahati, which has no jurisdiction. Then I filed the execution in Shillong. Executing proceedings are going in Shillong. Section 34 petition is filed at Guwahati. Ultimately, Guwahati court found that it has no jurisdiction. Application should be filed before the Shillong court. Then they withdrew from there and filed it here. Then there is execution petition filed. They filed a stay application of the award. Court said that you deposit 25% of the awarded amount. They have not the court, commercial court, also has not used the word 25% of the principal amount. Now, what the court has used is that deposit 25% of the awarded amount awarded amount, and on such deposit made, the execution of the award will remain state. What they have done, instead of calculating the 25% on the awarded amount,
That
they,
1 crore 80 lakh something, they calculated a 1 crore 36 lakhs.
they calculated on 136. And the commercial court found that it is at this point they have gone wrong. They have gone wrong, and they have gone wrong, and they have also gone wrong with regard to the judgments of the apex court, which I'll be just producing before your lordship. Now they are hampering on the point that since I have accepted that 25% of the amount, therefore I am debarred. I am debarred. This is not the law. This is not the law, your lordship. This was an interim order, conditional order.
No, if court said 25%, then
Yeah.
what should be the 25%? Your acceptance doesn't matter. Your acceptance will not make 25% 50%, isn't it?
Yes, yes.
If it is 25%, then 25% on the amount.
On the amount.
Now, the dispute is with regard to what should be 136 or 180.
186.
That is the thing.
That is the thing.
What is the awarded?
Awarded sum.
So entire
And if your lordship just take my written synopsis, which I have highlighted, just 1 second, then your lordship got it?
Yes.
I just read one first para.
Yes.
This revision petition under Article 227 of the Constitution of India arises from the order dated 5/2/25 of the Commercial Court of Shillong, by which the objection filed by the petitioner, judgment debtor dated 16/7/2024, in the execution proceeding has been rejected. At the core, the issue involved in the instant revision petition are as under. Your lordship, according to me, there are only two issues. What meaning to be assigned to the word amount?
Exactly. That is very much correct. That is what is needed to be.
The amount awarded.
Yes.
In the award dated 30/12/2016. Second issue is whether the arbitral tribunal awarded the post-award interest from the date of award only on principal amount found due to the respondent.
That is one.
That is 1 crore 31 lakhs, or on the aggregate of the principal and interest. That is
That
one.
is, your second question is dependent on the determination of the first question.
Yes, your lordship.
Once we come to the
Yes,
conclusion,
if
that
your-
will answer the
if
second.
your answer, if the answer
More or less
of the
same.
first, and
Based
then,
on the same thing.
Yes, these are the two issues, your lordship.
Come, let us go to the award again. Just let us appreciate page 68. Let us just see what is the language there.
Should I read in between where the act?
That is only that part. That is only that part.
We also
Hereby
award.
unanimously, yes.
We also award.
But just before that, we hereby unanimously award a sum of rupees so and so in favor of the claimant 131.
Yes, all right. Right, sir.
And direct the person shall pay the same full fine settlement all dispute. We also award.
Yes,
So
Lord.
then that also becomes a part of award.
Yes.
Isn't it? So this interest also become a part of award. So what is the language?
Yes. Interest becomes part of the award.
So that has been specifically provided here.
Yes.
See, the term we also award has been used here, isn't it?
Yes. And the purpose for which this provision is added because of the quick payment. What happens? Because money is blocked at one place. Now, if the contractor gets that money within a reasonable period, there is a circulation of money in the market, and the economic aspects is taken into consideration that this is a small award of 1 or 2 or 3 crores. We are dealing here where the award is 1,000 crores, and money is blocked with the government of India, and contractor is not able to complete the project, and it is lying incomplete. So therefore, Your Lordship, to deter the public sector organization or to direct the government which are allotting the work to make a quick payment, they have made this provision that add interest with the principal amount at the time of making the award, and the post-award interest should be on the aggregate of both. If Your Lordship is clear on this point, then I can go ahead with the judgments. And the interim payment, Your Lordship, is made after 3 years. After 3 years of passing the award. No, that also carry the interest, no? Now, what my learned friend has argued on that day, that the pre-award, that interim payment which is made is to be deducted from the principal amount. That is his case.
From that 131.
131. And which is not supported by any law. Even I will refer to that Morgan security case which he has heavily relied and has read out the word by word.
See, why should we look at the matter by making it complicated? We do not understand. See, award is in
Your Lordship, when something is decided before Your Lordship, we are to deal with that.
No, definitely.
Maybe.
We do not say before we go into all those decisions.
But not relevant.
See, even if we find, say, supposing it cannot be anyone's case at this stage, this award was not valid.
Yes.
Since it is not under challenge anymore.
And they have made the payment.
So whatever amount is there. So what we have to see, only thing is that what has been, the calculated is in terms of the award.
Term of the award.
So that is, our scope is not beyond that.
Definitely
not travel beyond.
And my learned friend is trying to put word principle in the award which are not there.
Now, according to you, the award includes that 131 plus the interest of 12%.
Yes.
That is
the sum awarded.
Yes.
Sum awarded.
Award interest. Yes. The second part of the sentence makes it a bit confusing.
Which one?
Jindal. If you read if you continue reading this amount, that slide, we also award and direct the respondent shall pay a simple interest at the rate of 12% on amount of such and such against claim number 1, 2, 3, 4, 5 and 6.
Yes.
And on the award amount of so and so on claim number 7.
Yes.
From 57 and 37 respectively, being the date of submission of
SOC. That is
so
statement of
the rate, the percentage of interest which has been awarded
it remained
for pre-award claim.
Lordship.
The same rate is maintained for post-award also.
Post-award with a rider that the payment is made within
90 days.
90 days, and if not made, we cannot segregate this part.
No, It is only the language here which creates a bit confusion.
Possibly according to my.
This is see,
and
respectively being the
no, Your Lordship, this is
see,
this
for
is
claimant till the date of payment of the award. Now that
Lordship,
is where this confusion
Lordship will
comes.
also look into one aspect, that all these three arbitrators are the engineers. Engineers. I haven't seen such a award, so I give plus point to this award. Written by the engineers. Engineers.
There is no judicial member here.
They are not. There is no judicial member. No judicial member. And what they have reproduced, it is appreciable, Your Lordship, according to me. According to me. And there is no absurdity which I found. My friend is reading, is trying to say that they have not awarded the post-award interest on the entire amount. They awarded
Because of the continuation of the sentence.
continuation of the sentence,
this
then
is
it goes further.
The arbitrator did not stop by saying that interest with effect from such and such date till the passing of the award. Then you see, the amount awarded shall further carry interest of such and such.
That, Your Lordship, every
Now,
person.
that is where the.
But Your Lordship also will find that the phraseology used give that sense.
Now we have to apply our understanding here.
Yes. And I'll show you the similar type of order passed in the Morgan case, which is cited by my learned friend.
No, see, we are not at all on the question whether that could have been awarded or not, or could not have been awarded or not. We are also not on the question that a part is awarded and part is not awarded. We are not on that. We have to understand only that line, nothing else.
And nothing. And Your Lordship, if the contention of my learned friend is accepted, then we are incorporating certain thing in the award which are not there. Where from that the principal amount? They haven't said that the post-award interest will be only on the principal amount. The 12% throughout the period they have taken. But with regard to the post-award interest, they say they make a payment within 3 months, 12%. If you do not make payment within 3 months, then after every 2 months, there will be hike of the interest.
2%. No, but then I think, see, this when you filed the execution, you have taken into consideration all those calculations.
Yes.
You have made it. Now, so far the pattern of calculation is adopted. There is no dispute.
No dispute.
Only thing is that what should be the
Amount.
awarded award.
What should be the awarded amount, and
That
up
is
to
what.
pre-award interest, up to pre-award period, no dispute is coming.
See, that means whether that the inclusion, whether this inclusion of pre-award interest
Lordship.
into the sum of as award, that is what the question is.
That is what is decided by the
Now,
Supreme Court.
if that is the law,
Yes.
then they do not have a case.
They do not
And
have.
if it is not the case, then
Then, Your Lordship, I have no case.
you have no case.
No case.
Now-
As it is as simple as it is.
Now, what the law says that this should be included
Yes,
in the award.
in the award.
It becomes a part of the award.
It is a part of the.
Whether specifically
Sometimes
mentioned
what
or-
happens, the pre-award interest is not granted. Pre-award interest is not granted for the reason that there is a contract between the parties which says that that interest is not payable. In that case,
No.
arbitrator lacks jurisdiction to award interest.
yes.
To award interest.
If it is, yes.
Yes. Then what will be the sum awarded? Only the principal. Only the principal. And where the arbitrator says that no, we award pre-award interest on such and such claim, but we don't award.
These are not our case here. Here, admittedly, interest is awarded.
Interest is awarded.
So whether that will form a part of the award or not, that is the law.
Yes. That is for that your lordship has to look into the law.
But then the thing is that if it is, so far as this award is concerned, if it is, if a calculation is made without including that amount, that pre-interest awarding, see what is there any variation? See, this pre-interest award,
Lordship.
which you say becomes a part of the award, isn't it?
Subsequently, it becomes a sum
It's a
or
sum
awarded amount.
That is award, that becomes an award, isn't it? That is
Yes.
included in the amount of award.
Yes.
Now, if we make calculation by including it or excluding it, which way it makes a difference? Does it make a difference? Because
It will make a difference.
Because
Your
two
lordship,
different-
we are to give a pause at the
No,
stage
yes.
of the award when
because,
it is
see,
made.
it is because two different effective date is given.
Yeah, two different.
For one amount, it is from 5/7/2013.
Yes.
And another is 21/3/2015.
Yes.
And that is where the difference comes.
Yes, that is how the difference is there.
Otherwise, it will be same. If you calculate it, amount will be same.
My lord, the whole issue starts where my 32 lakhs was adjusted. What they have done, first they take the awarded amount. My lord, the directive part is very definitive as to what is the awarded amount. If it was definitive of the total amount, then the pre-award interest was for a specific period. The post-award interest, no tribunal could not have predicted as to when the payment will be made. But the pre-award was static. What the respondents here they did, my lord.
Wait. We'll just come for a reply for you. See what this court is asking about, the calculation.
My lord.
Normally, even if we take into consideration Mr. Jindal's submission,
my lord.
And by the time being, whether, see, without going into the question,
my lord,
whether this amount, the pre-award interest should be included in the, as sum of award or not.
My lord.
Say, supposing in a case, if the effective date for charging interest is same.
My lord.
Now here this
two different
award, there are two different award, and it is made effective, the interest is made effective from two different dates.
My lord.
Isn't it? But then had it been on the same date, then there would not have been any difference.
My lord.
Calculation would have been same. Your calculation and his calculation would have been same.
My lord, if I may, my lord, on the law aspect of the pre-award interest, the learned senior will lead, my lord, when he replies to it. My lord, what the technical aspect on the calculation sheet, what they did is, there was an awarded amount, then there was a pre-award interest. They added it at the eve of the award. On that, they started a new interest component which they generate. Now, when I deposited 32 lakhs, they minus the 32 lakhs not from the awarded amount. They minused it from the second interest component which they started. Then they add another interest component to the 32.
So that means the calculation was wrong. Then it was done, that means the very arithmetic which was adopted,
My lord.
calculating, that is wrong.
My lord,
Then we don't, see, in that case we do not come into a question of law. So there is no calculation remains. If you can show that this has been done wrong.
My lord, it is on their sheet. The sheet itself says. So then what they did is, then when they adjusted the money from the interest quotient, then again they took that interest, again added it to the principal amount, and then again started a new interest on it. So what they have done, they have taken the interest 3 times separately, always added it into the amount, and then again levied a new interest. But the 25% was never a definitive amount, my lord. 25% was a arithmetic calculation of something which they agreed to. The court did not say the amount will be 32,69,125. The court said it will be 25% of X. So that is why in principle.
No, but then X must be known, isn't it? Otherwise, how 25% will be calculated?
My lord, that is what the X was the awarded amount.
Dispute here is that what is the awarded amount?
My lord, they agreed to 25% of 1 crore 31 lakhs.
If they say that they have wrongly agreed, then what happens?
My lord, today they cannot say I have wrongly agreed. Or in the calculation sheet, they could not have said I have wrongly agreed.
If you want to say, like, if there is a wrong arithmetical calculation on their part, there is no chance of the same thing being getting corrected.
My lord, chances, if it is on the
Any bar in the law for doing
no, my
that,
lord.
then?
My lord, the problem in the whole calculation becomes first is the interpretation of the law, which they are interpreting it in a way which is opposite to what we are interpreting, and I would rather say the correct position of law. Based on that, the calculation they are coming up with does not fit itself in the principles as have been established by law. My lord, the senior, he will reply to it once sir finishes, my lord, but the calculation sheet of theirs at page number 318 itself shows how the calculation has been done. My lord, we have stopped till the...
This court still has some doubt with regard to the calculation. See, like, either way,
my lord,
whether that amount is included, the pre-award interest,
my lord,
is included or excluded,
my lord,
if we calculate,
my lord,
ultimately rate thing will become same. It has to,
my lord,
because you see, the one thing is that this award is for two different amount. You see, one in relation to claim number 1 to 6, and second in relation number claim 7.
My lord,
the rate of interest and the effective date has been made that way. So, even if you include or you exclude,
my lord,
if you are to follow the rate of interest as prescribed by the award,
my lord,
calculation will become same.
My lord, it would have become same if the principle was applied which exists. The problem here is, my lord, the two components.
Just a minute, exist, which exist means what?
My lord.
Say, out of that entire amount of 131,
my lord,
it was divided into two.
My lord, it was divided into two.
See,
claim
from
1 to
from one part, it is made effective from 5/7/2013.
Only the pre-award interest.
Wait,
my lord.
The second part, it was made effective from 21/2015.
My lord.
And the rate was what was prescribed?
12%.
12%.
My lord.
Till if it is paid within 90 days.
On the eve of the award, my lord.
Okay. So, on the eve of the award means?
On the day the award was passed,
yes,
till the day of the award.
See, till this rate of interest was supposed to carry, it was supposed to be calculated till the date of payment, isn't it? Payment of the entire award.
No, my lord.
Why not?
My lord, if we see the directive, it was only till the date of the award.
See,
if I may, my lord. And then a 90-day grace period was given without any interest.
Till the date of payment. What is that?
My lord.
See, respectively being the date of submission of SOC for claim number 167 till the date of payment of the award by the respondent. Yes. What means? It is there. It is mentioned till the date of payment.
My lord, if I may just read the operative part once, of the award.
See, this court still finds that why there is even if that amount is the both ways.
My lord.
It is your way or the senior counsel's way.
My lord.
Whatever you see, arithmetical calculation you take, the amount would come to same. Until and unless there is a miscalculation, double calculation and triple calculation.
My lord, the calculation error comes when I pay the 32 lakhs.
It is becoming, it seems more to be a case of, you see, like a dispute regarding arithmetic, not law.
My lord, law is the interpretation how it is being done, it is there. Now, my lord, what they did is, let us hypothetically assume, for the sake of argument, that at the eve of on the day of the eve of the award, the amount is 1 crore 86 lakh as per them. Now, my lord, interest will start after 90 days, 12%, 14, 16 and 18% every quarter. My lord, when I paid 32 lakhs, they minus the 32 lakhs from the accumulating interest, not the principal.
Even if you pay till 90 days, you have to pay the 12%. And this 12% gets enhanced by another 2%
every quarter. My lord.
Post that 90 days.
My lord.
Subject to 18%.
My lord.
Isn't it?
My lord.
Now, we are not going into that. We are saying, why to go into all those aspects? See, the award remains otherwise very much clear. For sum of 126, you have to pay 12% interest with effective from 5/7, and for a sum of rupees 5 lakhs, you have to pay interest at the rate of 10% with effective from 21/3 to 2015, and interest to be paid till the date of realization.
My lord.
That is what. Nothing more. Why should we add something and subtract something from there if it becomes so simple? Only thing is that we have to take into consideration on which date you have made the payment.
My lord, the 25% which I paid, that was supposed to be adjusted against the principal.
Okay.
They adjusted it against the separate accumulating interest as per their calculation. Then they put another interest on 32 lakhs. Then
How much difference comes in overall calculation?
My lord, almost 2 crores.
2 crores difference.
Almost 1 crore 80 is the difference.
Why so much?
My lord, because they calculated it in a compound interest formula. They always take the interest, keep it separate, then again add it to the principal. Again, at any event, they will again take the interest
No, but
separate.
then the senior counsel said that there is no dispute with regard to the award of simple interest. He says that is simple.
My lord, after the award, if the sheet is perused, there are several stages where there are new events which have taken place, like the event when I paid 32 lakhs. We see the whole calculation and the interpretation of law has been interpreted differently than what it exists, and the calculations have changed. So my lord, once sir completes, we'll come back with the sheet. And
But then you see, like now things, you don't know, things are taking in a different.
My lord.
Different. Now, otherwise, this court fails to understand whether you include or you exclude. But the senior counsel says calculation would be same until and unless there is something wrong in the arithmetic.
My lord, once we come back with the law on it, and then we will show how the calculation does not befit what is being projected or what the learned senior.
Do we do the arithmetic in our revision of jurisdiction to what extent we can do it?
No, my lord, we will not go into it.
If any wrong method of calculation is,
my lord, maybe the matter will have to be.
Do we correct that wrong in our revision of jurisdiction?
No, my lord, maybe the matter will have to be referred back if we can demonstrate that we have a case and there was the court had erred in interpretation of law.
You can demonstrate only when you see we do the arithmetic. Otherwise, different.
My lord, purely on the interpretation of law as to what would be sum, what would be principal, how they will be added and how they become a component.
See, what would be the sum, what would be the interest? No, we do not know. Even if that be the thing, the difference cannot be something like 2 crores. We do not know. That is normal assumption.
My lord, it is. That's how it exists. My calculation showed we had to pay them 2 crore 98 lakhs, which we have paid them. As per their calculation, my lord, it was 4 crore 43 lakh 81,000, my lord. My lord will see both the comparative statements at page 318, there's 307 mine.
Is it reflected in the impugned judgment? No.
My lord.
Now, page 307, that has been pointed out by Mr. Jindal here.
My lord.
You see, your calculation, so far as the rate of interest is concerned, and his calculation is same. Only difference is that you did not add that interest.
My lord, we say that the interest quotient will keep on carrying on. When I make the payment, that is the time when my payment will consist of two components: the principal, the awarded amount, and the interest accumulated. When I make the payment. But what they did is, my lord sees my calculation sheet. If I can take my lord through my calculation sheet, my lord.
Yes, I'm there on page 307.
My lord.
This code is there.
My lord will see first entry.
Yes, we have seen that. You do not have to see, Mr. Khera.
My lord.
So far as this thing is concerned, it is still that much. The calculation is concerned. This court has no confusion.
So, my lord, we can come to the middle of my
Only
sheet.
thing is that if we come to the calculation of Mr. Jindal, what appears to be, so far as the first part of the sheet is concerned, what appears is that they have included that interest part with that
My lord,
131, that principal level.
my lord, if I may.
Yes, yes, why not? You are,
My lord, page 3, if we could go through my complete sheet once,
Yes.
and then we go to the sheet of the respondent herein,
Yes.
we'll be able to better understand where the difference has come.
Yes.
If I may, my lord.
Yes, you're.
My lord, page
please.
307,
Yes.
at the middle, pre-award interest on claim number 1 to 6 and 7.
Yes.
That is 54,14,578 rupees. At the middle of my sheet, my lord. My lord, after that, interest as per award on the principal amount, that is 1 crore 31 lakh.
We're trying to locate first which part you are reading.
My lord, entry number 4 in bold, my lord. Total pre-award interest on claim number 1 to 6 and 7.
Total claim, no, 1 to 6 plus claim 7, which is marked as A.
My lord, my
Yes.
lord, the award was for 2 claims. Claim number, one set of claim was 1 to 6 and the second was claim 7.
Okay, that is on the top, yes.
My lord. So after that, my lord, we have calculated the interest, and the interest amount for claim number 1 to 6 is 53 lakhs 870 rupees. For claim number 7, the pre-award interest is 1 lakh 13,708 rupees.
Same with them.
Same. Now, my lord, the total awarded, the total pre-award interest comes to 54 lakh 14,578 rupees.
See, so far as their thing is that they have added these two amount and calculated the total claim on the date of the award.
My lord, that is where we say that they could not, to understand this, my lord, allow me to proceed ahead in my calculation sheet to understand this position a little better, my lord. My lord, they go on. Now what we do is interest as per award on the principal amount. Principal amount is claim 1 to 6 plus claim 7, which is a total of 1 crore 31 lakhs 87,889, my lord. Now we break this up from 31/12/2016 to 31/3/2017 for first quarter at 12%.
That is 90 days.
12%. From 1/4/17 to 36/17 the second quarter, 14%. So on 16 and 18%.
That is where it appears to be wrong.
My lord,
see, that is why this court is asking right from the beginning why there is a difference of amount.
My lord.
You see, it should not have been. Even say, you see, Mr. Jindal's calculation, these two amounts were taken up together and they can give a total of amount due
My
as
lord.
on the date of the award.
Well, they could, that the law says they could not have.
See, then we do not know,
my lord,
that why that other amount, the amount which was due.
My lord, it was claim 1 to 6 and claim 7 which was the actual amount. The awarded amount, the operative part of the award very categorically says what is the awarded amount and how interest will be calculated. Now, my lord, on 27/8/2019, I make a payment of 32,96,972.
Where is that mentioned?
My lord, just below the calculation. 12, 14, 16, 18.
And amount deposited with the court.
My lord, and withdrawn by them.
Okay.
Now, my lord,
it will be an estoppel if they withdraw. Will it operate as estoppel against them?
No, my lord, that is not my case.
No, I'm just saying. Say, supposing if they withdraw,
my lord,
can they subsequently dispute that amount?
My lord,
By saying that it was not 25%, it was less and all. Can they?
My lord, we will have to go and see the orders that were passed when this 25%.
What the law says? Any estoppel comes here.
My lord, they have agreed to this calculation of 25%.
That means you are saying estoppel would come.
My lord,
say something.
No, I am, my lord. I'm coming to it. My lord, after this, what happened? We say that this 32 lakh will be minus from 1 crore 31 lakhs. What they did here is, my lord, they
Now,
took.
this court got the point now. We understood. Now everything is different. You see, moment you have started calculated by taking 131,
My lord,
and they calculated by 186.
my lord,
Difference is
they did not even calculate on 186. What they did here is, they took 186, then they started putting the interest at 12, 14, 16, 18 on 186.
But then one thing you just tell us. Okay, that is why you see, because your calculation, since you have calculated that. No, but then even then also, why there is a difference?
My lord, permit me a minute. My lord, what they did is, on that 186, they started accumulating interest at 12, 14, 16 and 18%. When I deposited 32 lakhs, they did not minus it from their so-called 186 also. They minused it from the interest that they were accumulating. And then they took the remaining interest and again put it into the principal. It is not their case that they minus 30, my lord, 32 had to be 25% of something. I am saying
you paid 32 on a certain date, isn't it?
My lord, what they did is,
just a minute, just to clarify.
My lord.
Now you paid 32 on a particular date.
My lord.
But then, so far as the 25% calculation is concerned, you have basically calculated on the basis of the amount which is reflected in the award.
The awarded
That
amount.
is 131.
My lord.
Isn't it?
My lord.
But then for them,
My lord.
this amount varied.
My lord.
Because of the inclusion of the.
My lord. My lord, hypothetically, assuming not accepting that 186 was the amount.
To them, that 25% would have been something higher than the 32.
My lord, but it should have been minused from where? It should have been minused from hypothetical.
It depends upon you minus at what stage from where. Otherwise, if you minus from interest, you see, when you go on calculating interest,
My lord.
further, then definitely, if it is not deducted from the principal amount, then interest will keep on piling more.
So that is, my lord, they never deducted from the principal. So for the sake of argument.
Yes, but
They-
then say supposing,
My lord.
if we say that their interpretation of what should be the decretal amount or the awarded amount is correct,
My lord.
and their calculation of interest is made by deducting the 32 lakh from that 180, then there cannot be any more wrong, or there no wrong can be imputed in to their calculation, isn't it?
My lord, the platform on
Our difference is only on that 131 and 186.
No, my lord. After 186, they never minus 32 from 186.
No, whether they have minused it from 181 or not.
No, they minused it from the new accumulating interest on 186. And then they took that interest, added to 186, and again started a new interest.
Now, see, that of course they could not have done it.
That is,
even if it is a payment of 25% decreted amount,
my lord,
if not 131, that should have been 25% of 186.
186. That also they did not do.
Is it?
What they did, when they made it 186 at the eve of the award, new interest started accumulating. As per them on 186.
So now another calculation will come. One will be according to you, or one will be according to Jindal, and one after taking into consideration 25% of that 186.
My lord.
So that will be calculation by the court, isn't it? Now that is where we are landing up now.
My lord. So my lord, let Sir Jindal finish. My lord, we'll come back with a reply. There is no other way out.
No, then if you say,
My lord.
if you say so, 25%.
Yes, my lord. And
Okay.
my lord, I will show it from their calculation sheet.
If it is a mere arithmetical wrong in calculation, we do not know, we say like whether, how much we can go into it.
My lord, it's an
But then,
arithmetical.
if there is a dispute with regard to the determination of the actual sum award.
My lord.
Now, the senior counsel has made a difference of that principal sum.
My lord.
And the sum. Now, according to him, it was sum, not the principal sum which has been awarded.
My lord.
Isn't it? Now, that will definitely take into, you see, it will include the interest. amount comes to would come to 186. Now 25% of 186.
My lord, not
Now,
accepting.
where it was provided the payment of 25%?
My lord, page 69,
Okay,
annexure A2.
page 69.
My lord.
Yes.
May I, my lord? The operative part, para 8.
But then it is not provided anywhere in the
Award.
award.
No, my lord.
That the 25% should be paid fast and then 75%
No, my
later.
lord. No.
Nothing like
No.
that.
Page 70, para
So this
8.
deposit of 25% is of your own.
No, my lord. It was for stay.
It was
And
for the stay.
my lord, para
And
8, as agreed by the parties.
Wait, just a minute. Stay. Okay, that is by the 34 court.
By the commercial court, my lord. But my lord, the order reads that as agreed by the parties, the operation of the award dated 30/12/2016 passed by the arbitral tribunal of
Okay.
page 70, para 8. If I may, my lord. That as agreed by the parties, the operation of the award dated 30/12/2016 passed by the arbitral tribunal of so-and-so, so-and-so and so-and-so shall remain suspended subject to the condition that the award
There
debitor.
seems to be a lot of disagreement in this agreement. This is 25%. It doesn't say about the amount.
My lord, of the awarded amount within 3 weeks.
That is what. What is the award? That is
My,
the dispute.
my lord, we are coming to it now. Now what happens is, I deposit an amount. Page
Yes.
71, annexure 3.
Okay, so you want to say, that is why I said, this court has asked you right from the beginning, Mr. Khera, this court is getting
My
its
lord.
understanding in which line your submission is going.
My lord.
Now you would say that, you would contend here that since they have accepted there is 25%, so now there is no occasion for them to stand up and say that that is not to do.
My lord, my stand is that this is the correct position of law, and they are deviating from it now.
Of course, that we understand.
And the second aspect, my lord, this 32 lakhs has to be minused from what? I say from 1 crore 32 lakhs. My lord, if my lord is of the view that it has to be from 1 crore 81 lakhs, still my contention is that they did not minus it from 1 crore 81 lakhs. Page 72, my lord, para 7.
Yes.
In view of the above, the respondent opposite party decree holder Mrs. Mega Electrical
Is allowed to withdraw. So
withdraw,
so
and my lord, they withdraw the money.
that's all right. So that is why this court is asking you whether that withdrawal will prevent them from subsequently
My lord,
disputing the summon.
my lord, sir began the argument unless otherwise agreed between the parties. Now, my lord, had I deposited,
That is with regard to you. Why you are going to? That is with regard to the agreement. You see,
my lord,
it has nothing to do here.
had I deposited, my lord, hypothetically speaking, had I deposited only 1 lakhs, would they have agreed?
Your agreement has lost relevance after the award has come and award achieved finally.
My lord, no,
we will go by.
My lord,
stipulation, yes.
if we see their calculation sheet at page 318 now, how they took this 32 lakhs to minus it from adjust it in which account?
So now the problem is that Mr. Khera, if your submission is to be accepted, then court will have to arrive into a different rate. Now court will have to first see.
My lord, I am only assisting the court on
Even
figures.
say supposing after court determines what is the awarded amount,
My lord,
actual awarded amount,
my lord,
then court will have to again see that whether calculation made by the parties
my lord,
are in terms of the award.
my lord, because we placed the law before the court.
Do you do this task under 227?
My lord, but we placed the law before the learned commercial court. The learned commercial court, in our opinion, my lord, could not interpret the law.
Did not appreciate it in proper process.
My lord, that makes me stand before my lords under 227.
We understand. But then now, as it seems like, now you see your contention before this court is now not only confined,
my lord,
to the objection against the inclusion of the
my lord,
interest. You say that subsequent calculation also is wrong. Now this was not the position when Mr. Kumar was arguing.
my lord, I am only being of assistance on the calculation sheet how they exist, my lord. On the law, senior counsel will be
You are
leading
doing
us.
it very efficiently. But then now you have given us a different page.
My lord, just the calculation how calculation was done, learned senior will be leading the court, my lord, as to the law under which the calculation should have been done.
No, he has pointed out to some extent.
My lord.
Of course, he may have something to say in his reply.
My lord.
But definitely, that we can understand.
My lord, on simple...
Now, it means this matter will not be solved even if we decide what should be the arbitrated amount. Isn't it? The matter doesn't rest there.
My lord, I will only be in the prism where I will say that 32 lakhs has been wrongly adjusted with the interest. Whether my lord decides it was 132 or 186.
Now, whether the arithmetical wrong should be corrected by her 227.
My lord, the view taken by the court below was with all humbleness, my lord, was faulty interpretation of the law to the extent that I interpret the law in this manner. Thus, this calculation takes refuge and shelter under the interpretation. What we say is the refuge given to the calculation does not befit what the law prescribes, my lord. If it has to be interpreted the way...
That is why you are here.
My lord.
If you do not do that, then why should you be here?
My lord. My lord, let's continue, and learned senior will... I think I have spoken much out of place.
The problem is that even today also this hearing could not be concluded.
My lord.
Now this has become quite complicated now.
No complication, Your Lordship.
Yes.
In fact,
that is, see, Mr.
no
Jindal,
complication, Your Lordship.
your grip over the subject and the court's grip over the subject is not same. So that is what the difficulty is.
Only thing, the placement of the facts are, as per
Now,
the...
Mr. Khera has further submitted, you sit down. Mr. Khera has further submitted that it is not only that you have miscalculated what should be the awarded amount, your further adjustment of the 32 lakhs which they have paid, that is also wrong.
He's
Now, of course, you have not addressed the court on that.
He's absolutely wrong. First thing, Your Lordship, no answer is coming either from his senior or from him that a sum of 25%, that is 32 lakhs something, was deposited on 27/8/2019. And till that period, it must have carried the interest. 32 lakhs. 32 lakhs.
Yes, what you said, that also seems to be quite reasonable.
And no answer is coming from them that why they have not taken.
And then what happens if you have not disputed that amount?
Which one? Yes.
The agreement was that they will pay 25%.
Yes.
And on
Yes,
payment of
Lordship.
the 25%,
No, Your Lordship.
the decree would remain stayed.
No,
And
Your Lordship.
subsequently, you accepted that amount without
This
any
is-
objection.
This is...
Now, on the basis of this fact, whether estoppel comes and
it doesn't come at all. It is a conditional order. Conditional order. And the amount was ordered to be adjusted from the final award.
So it means it has no bearing. Whether
No
you-
bearing at all.
Whether
Save
you-
and except to get the date on which they have deposited
Whether
the money.
acceptance was under
And the interest on this amount will cease to accrue with effect from the date on which the payment is
So,
made.
according to you, on the date of payment of 25%.
Yes.
In August 2019.
Yes.
What should be the amount of 25%? Should have been the amount of 25%?
25%,
Not 32, but then what should have been? According to you, what should have been the amount?
it should have been little more because they have calculated it
So that part amount
on
was
131, and whereas we have claimed at 186. 186.
So they have kept that 131 intact.
They kept it 131.
It becomes
they kept
static,
it at
became static,
131.
it did not move.
No,
And for you, just it kept on increasing.
kept on. Your Lordship will come just page 318.
318.
The second block,
Is there any manner specified or any procedure specified anywhere in which manner
yes,
the
this has to be done.
the calculation has to be done in the execution?
Yes, it is there.
Where do we get it?
Hyder construction. Consult.
In any enactment and all, any thing, either construction.
Yes,
an
that is the law.
Whether is there any enacted law?
Statutory, there is no provision, but they have interpreted clause B. What does the sum means? They say sum is the total aggregate of the principal and
That is what
interest
has been
accrued.
pointed out. But then that the subsequent decision
Of Morgan Security. That your lordship has got also has got no bearing, because in that case, Morgan case, arbitral tribunal has awarded the post award specifically on principal amount. They have used the word that we award so much percentage of interest on the principal sum, meaning thereby the arbitrators have applied their mind.
But then this use of word principal sum is not where they are in the Arbitration Act.
No, it's not
It's
there.
nowhere
No,
provided
it's not there. It's not there. In Morgan Security case, the stand of the contractor was this, that that I'm entitled for post award interest both on the principal plus interest accrued. Now the apex court said it. No, arbitrator also has the power to determine the period. Also, earlier position was this, that the so far post award interest is concerned, that it will only decide the rate of interest. Rate of interest.
But then you have made reference to that 31(7)(a).
Lordship.
That is even the date also, effective date also, isn't it?
Yes, your lordship. Effective date also, and the arbitrator also has the power.
So earlier view was prior to 1996.
1996, your lordship, prior to 1996.
What you are saying about the earlier view here,
Earlier
that
view-
it refers to prior to 1996.
Earlier view, your lordship, was contained only in section 29 of the Arbitration Act 1940.
Anyway, do not take us to there if it is not relevant here.
No, it is relevant for the purpose of understanding. Now, earlier, your lordship, if you recall, the award of the arbitrator was just a piece of paper. Unless it is filed in the court and a decree is obtained. Decree is obtained from the court.
Maybe
from
it is
the
a
court.
rule of something.
Rule. When the award is made a rule of the court, then only it becomes a decree. But in 1996, it is deemed to be a decree. Deemed to be a decree, especially for the purpose of executing the award. That difference is there. Now, Section 29, your lordship, of the 1940 Act, I don't know whether.
Anyway, is there any purpose of referring that section to?
Not as
Anyway, so far-
lordship is aware of this. Now, what was the law prior to it? That was laid down in SL Aurora, state of Haryana. Your lordship, I have given my compilation of the judgments.
You have submitted a separate compilation.
Yes, of my judgments. There are 6.
Yes. Yes.
Your lordship, I'll take first the facts. Facts. Paragraph 2, page 27. No, I'm sorry, sir. I'm sorry, Lordship. Paragraph, page 1. Page 1. State of Haryana and others versus SL Aurora. Paragraph 2. The paragraph 2, Your Lordship. Got it?
At page 4.
As page 4.
Yes.
The operating portion of the award is extracted below. I award rupees 14.94 lakhs along with interest at the rate of 12% with effect from 19/12/1990 till the date of award of Messrs. SL Aurora and Company, SE so and so, to be paid by the Haryana PWD BR branch department in case the total amount of award together with this interest is not paid within 30 days from the date of making the award. Future interest shall be paid at the rate of 18% per annum on the sums due to the claimant from the date of award up to the actual date of payment.
Which clarity is missing in this present?
It is missing, Your Lordship. It is missing, Your Lordship. Now, Your Lordship, this was interpreted by the apex court. There were 2 points which were raised in this paragraph 8. On the contentions arts, the following question arise for consideration. Whether section 31...
Para 8.
8. Whether section 31(7) of the Act authorizes and enables arbitral tribunal to award interest on interest from the date of award. Whether the arbitral award granted future interest from the date of award only on the principal amount found due to the respondent, that is so and so, or on the aggregate of the principal and interest up to the date of award. So that is the question. Question is before my lord in our case.
See, probably you do not know, subject to
Lordship.
clarification by you. This SL Aurora case
is overruled.
Where the award was under challenge.
Award was,
we have crossed
and
that
that petition was dismissed.
Whatever it is, see, we have crossed that stage.
Yes. Now, only the thing, Your Lordship,
Yes.
what I am trying to point out is this, that law prior to Hyder construction was contained in SL Aurora case. Your Lordship will come page 12, 24.6.
See, these decisions,
Lordship.
at the best, may clarify
Yes.
to the point whether there can be interest on interest or not,
Yes.
or what should be. But the thing is that, in the present matter, we are slightly on the different votings.
Yes, yes, Your Lordship.
We are concerned with the pattern of calculation, basically.
A pattern of calculation,
And
how
then-
the principle.
See, what should,
the
yes,
principle.
that is the question.
That is the only question, whether for the purpose of granting post-award interest, the sum should include only the principal, or it should include principal plus interest.
Now, just to make it more specific, whether pre-interest,
Yes.
pre-award interest,
Yes.
should become
a part of the
part and parcel of the award, the
Award.
sum award.
Yes.
That is
Yes.
so.
In
Just
this
we need
case,
clarification on that.
yes,
Rest everything will be dependent on the calculation.
yes. Then those are calculation part. When
that
the
can be
principles
done
are set, this court cannot do the
No,
calculation.
we will
for
not
the
go into all those things. What we are just trying to determine to that what should be the
calculation.
what should be the
principle
award,
of
sum
calculation.
award. What should be the sum award,
Yes, Lordship.
not principal sum.
Yes. Now, page 12, 24.6.
Of the same decision.
Yes, same decision. Clause B of section 31, Lordship.
Yes.
Clause B of section 31(7) is intended to ensure prompt payment by the award debtor once the award is made. The said clause provides that the sum directed to be paid by an arbitral award shall carry interest at the at the rate of 18% per annum from the date of award to the date of payment, if the award does not provide otherwise in regard to the interest from the date of the award. This makes it clear that if the award grants interest at a specified rate up to the date of payment, or specify the rate of interest payable from the date of award till the date of payment, or if the award specifically refused interest, clause B of section 31 will not come into play. But if the award is silent in regard to the interest from the date of award, or does not specify the rate of interest from the date of award, then the party in whose favor an award for money has been made will be entitled to interest at the rate of 18% per annum from the date of award. He may claim the said amount in execution even though there is no reference to any post-award interest. Here your lordship will find even during execution he can claim.
That is okay, but then we
No,
don't have any problem
yes,
so far as this proposition
that's
is
true, your lordship. Now, just come to concluding para of 34.
Just show us the part which would help us to determine.
Yes, now I'm
what
showing
should
the,
be the-
I'm making endeavor to show your lordship that what was the law prevailing prior to that, prior to Hyder
That is
construction.
okay, but then see, so far as the rate of interest
Yes.
is concerned,
Yeah,
there appears
we are
to be
not
no
concerned.
dispute. Mr. Khera also is not disputing anything. You
No,
see, you also are not disputing.
Not disputing. We
But
cannot
what
also.
should be that amount on
Yes.
which calculation should be made?
Yes, or
That is
whether
the-
it should be on 131 or 186.
That is the question.
Simple
That is the crux of
question.
it. Nothing more.
Nothing
Just
more.
please give us something on that, whether it is
Yes.
131 or it should be 186.
Paragraph 34. Thus it is clear,
Of the same decision.
same decision, thus it is clear that section 31(7) merely authorized the arbitral tribunal to award interest in accordance with the contract in the absence of any prohibition in the contract and in the absence of specific provision relating to interest in the contract, to award simple interest at such rates as it may deem fit from the date on which the cause of action arose till the date of payment. It also provides that if the award is silent about interest from the date of award till the date of payment, the person in whose favor the award is made will be entitled to interest at the rate of 18% per annum on the principal amount awarded from the date of award till the date of payment. The calculation that was made in the execution petition as originally filed was correct, and the modification by the respondent increasing the amount due under the award was contrary to the award.
Has no application here
Yes,
in this case.
Lordship will come
Because we
to
are
the.
not at dispute so far as the interest is concerned.
Yeah, this is your lordship,
So-
the pre-award.
This SLR doesn't help us much so far as
No,
this
it
case is
doesn't help at all, because this is overruled.
Okay.
Overruled.
Okay.
But that was the law prevailing.
It is overruled by
Then
Hyder
Consulting, your lordship will just see the facts, paragraph 2 and 4. Paragraph 2. It is not possible.
This is a three-judge decision, isn't it?
Yes, this is the law which has been accepted.
Yes.
It is not possible to agree with the conclusion in SL Aurora case that section 31(7)(b) of the Act does not require that interest which accrue till the date of award be included in the sum from the date of award for calculating the post-award interest. In my humble view, this conclusion does not seem to be consonant with the clear language of section 31(7) of the Act. SL Aurora case said it, that the interest cannot be included in the principal for the purpose of the post-award interest. This judgment says that it is not possible to accept that proposition. Then paragraph 4. Clause A of subsection 7 provides that where an award is made for the payment of money, the arbitral tribunal may include interest in the sum for which the award is made. In plain terms, this provision confers a power upon the arbitral tribunal while making an award for payment of money to include interest in the sum for which the award is made on either the whole or any part of the money and for the whole or any part of the period for the entire pre-award period between the date on which the cause of action arose and the date on which the award is made. To put it differently, subsection 7a contemplates that an award inclusive of interest for the pre-award period on the entire amount directed to be paid or part thereof may be passed. The sum awarded may be principal amount and such interest as the arbitral tribunal deem fit. If no interest is awarded, the sum comprises only the principal. The significant word occurring in clause A of subsection 7 of section 37 of the Act are the sum for which the award is made. On a plain reading, this expression refers to a total amount or sum for the money for which the award is made. So here they explain the what is meant by term sum.
So here, if you go by this interpretation, that means yes, interest can be included. It becomes a part of the
award.
Pre-interest, pre-award becomes a
Yes. Then, Your Lordship, I go a little further.
Yes.
The Parliament has not added a qualification like principal to the word sum, and therefore the word sum here simply means a particular amount of money. In section 31(7), this particular amount of money may include interest from the date of cause of action to the date of award.
See, now the problem is that the use of word may here.
Yes.
It never says shall.
It doesn't say, but it says that sum means what? Sum means the principal plus the...
No, see, the earlier Mr. Kumar's argument was based on that only when he referred to the subsequent decision.
Yes.
Clarifying this. He said that, see, the arbitrator has a liberty to include or to exclude. Okay.
Yes.
So until and unless that is specifically done, we cannot go by the assumption that has been included.
Yes.
The interest part has been.
Yes. Here the interest is specifically granted for the both. There is no dispute about this fact that the tribunal has not awarded the post-award interest.
But then it is not written exactly the way.
No, till the payment is made.
You projected in
till the payment
SLR case.
No, till the payment is made.
That is where the problem is.
Till the payment is made.
This amount was divided into two parts, 1 to 6 and 7.
Yes.
The rate of interest was made applicable from two different dates.
Yes. Yes. And in between problem came of 25%.
Okay. Now, anyway, what you say, that is so far as air contention is concerned, that appears to be correct on the perusal of paragraph 4 of that Hyder construction.
Yes.
Okay. Now, you have to address us on that Morgan thing.
Morgan security.
We'll continue in the second half, or when Mr. Kumar will be.
My lord, he is there for the presidential reference in the Supreme Court.
When he.
Sir is there online now, but his link is, I believe.
I'm online, my lord.
You are not audible.
Am I audible?
You are not audible. You are not audible.
Your lordship can.
When he is likely to be available here?
My lord, after a week.
Because keep it partner.
My lord.
So that it comes at the top of the list.
All right. But other than Monday I am not here. Next.
Okay.
Am I audible?
Then after 1 week.
Tuesday.
My lord, can I
have to see our own roster also, Mr. Jindal. This court is dealing with criminal appeals also. So we have a huge pendency of criminal
commercial matter. There is a short of money in the market.
You can understand.
Unless the money,
even then, that cannot be given
cannot
priority
create
primacy
employment. It has got a great implication, Your Lordship. The money is blocked.
Article 21 The personal liberty strikes at the root of the thing. Anyway, we are not trying to draw impurity and all. But then only thing, see, Mr. Kumar is not at all
Audible.
Yes. No, my lord. Let Mr. Jindal finish his argument,
Kumar,
my
we
lord.
do not know
Let
whether we
Mr.
are
Jindal
reaching you or
finish his
not.
argument.
But then you are not at all audible. So, see, just you do one thing.
I'll run the date through both the seniors and the court master for the accommodation in the court.
Will it be all right for you? He communicates the date after 1 week,
Next Monday.
except Monday.
I'll just ask.
You ask from them.
I'll ask and
do
I'll
one
also
thing.
see from the court, my lord, the
Okay, just say hard learned counsel.
And I have placed your lordship one written bullet point. I gave it.
Okay, you submitted a bullet point. That you also you want to
Because
be, it to be recorded.
No, for them it was recorded. For them it was recorded.
Okay. The hard counsel for the parties.
No, my lord, what I will do, my lord.
General learned senior counsel.
May I submit, my lord?
Is also submitted
Bullet points.
bullet points of his argument. Also submitted a written bullet points of his argument. Stop. Then you just say next line. You just, then thereafter do not give paragraph. The hearing could not be completed. At least a matter. After a week, just give a proper on such and such. Okay, as parted. Interesting, but then okay, now this court.
No, your lordship
least
has got it.
got a better grip.
Got it much more. What I could have done it.
No, only Mr. Jindal, so far as your submission, now Mr. Khera, another day what Mr. Kumar has made, the matter only concerns about that, the determination what should be the, what amount,
What is some, my
actual
lord?
amount of award in this case. Nothing.
Nothing else.
We are not going
And
into the
for
question.
that, your lordship, there are judgments to guide us.
Yes, well, just there are judgments, and definitely the court will be looking to you just to clarify those judgments
Yes,
and all,
I'll do it.
and
I'll
which
do
way to be propositions to be applied. That is what.
Otherwise,
But
I
then
could have
we are
finished
not
my
at all
part
into the
today.
question of what should have been awarded and should not have been. That is gone. That period is over.
No, on factual aspect, almost I have submitted only on law point. I'll just.
You communicate with Mr.
I'll do
Kumar,
that, my
get into date, communicate with sir, and then.
I'll do that.
No, my lord. We can have next Tuesday, my lord. Next Tuesday. Next Tuesday, lordship.
Next week. Who is the other side?
Mr. Muzika is there, my lord. It is taken up next week. Second half, I have some difficulties. It can be taken up next week, my lord, as a fixed item.
This kind of service matters, we do not know after so many years what kind of relief. Even if you can make out a case. What is the vacancy position, Dr. Mojika, so far as the position
Vacancy
of
is
cook is
still there,
concerned? What is the problem if you accommodate him now? By this 7-8 years, he must have become expert.
And my lord,
Don't know what he's doing now. He's doing
my lord,
some other business now.
No, my lord. Other aspect also, my lord, this is even the trade test. My lord, in the army, directly after the written test, they are taken in, my lord.
See, just give us one decision, or maybe you see, you may not get it specific to I think. Just help us on the position.
It is only qualifying in nature, my lord.
With that, in a case, similar situation, where a candidate like you,
this is a very peculiar situation actually.
Chance. We should also be given the similar kind of gap to which the other regular candidates.
It's a very rare thing.
Very denial of that would result in
only difficulty, my lord. This is a very peculiar case.
So if you can go, otherwise you see what we understand, you say like you should be given a fair opportunity.
Precisely, exactly.
Determination of that depends on the court. Until and unless you can bind the court by showing some law. So that is what is the problem. You see. So now, if this court is expert in preparing chicken curry, he may say 5 minutes is not. So that is what the problem is. Anyway, just when
It can come up next week, my lord.
possible next week? No, after 2 weeks, Mister. Not possible. Yes. Any objection?
Yes.
Okay. just on prayer made by Mr.
It's 9 years, it will complete 10 years. So,
See,
My lord, I want
more
to finish it
the
before
employment-related cases, what this court feels is that if it is kept pending for quite long time,
it becomes unimplementable.
it defeats the very interest of the thing. Anyway, we just see, it is the desire of the petitioner, just on prayer made by Mr. Kapi Bhattacharya. Not objected to by Dr. Majika. List of 2 weeks.
Number 8 and 9, Mr.
May I, Lordship?
Mr. Kumar,
Yes.
8 and item number
You are
8
not
and 9,
audible,
my
Mr.
lord.
Kumar. What happened? Is there any problem with our system or checking? Please check. Anybody with Mr. Kumar in local council? There is no local council here.
Item number 8 and 9, my lord.
Because with Mr. Amit Kumar also we had same difficulty.
Item number 8 and 9 after 2 weeks, my
Local
lord.
council also.
You were there.
Let come after a week or 2, my lord.
Is it easy? Acha, okay. Easy. Okay.
You can hear.
This is
It's
also
okay.
as agreed by by the parties. Just on joint prayer for this matter after 2 weeks. 7 and 8.
8 and 9.
8 and 9.
8 and 9.
Okay. Yes. Thank you.
Well,
Yes.
well,
Mr. Khara.
Both the senior councils have agreed to 18th of September.
Yes. We'll.
1/8.
One is a holiday. 18th is a holiday here.
17th was Vishwakarma. They said that's why.
18th is a holiday here.
Holiday. I'll run through a next date.
You just give it. You do not need to communicate to the court. This may not be reflected in the order, but then I think she will list it. Okay. You just communicate the date to these things. We are not putting it in the order. Yes.
Only 2 and 3 are still there in the list, my lord. Those
Yes.
foreigners matter.
Yes. Oh, those matters, foreigners matters. Yes.
Are ready for second half?
Yes. So in the second half then. Yes, there is no other option, madam.
Yes.
Because matter is otherwise urgent, isn't it?
That is why. At 2 o'clock or 2:15?
It will be 2:15, madam. It cannot be 2.
Yes.
Second call, item number 2.
Yes, Mr. Dev, in your petition, did you say about when did you come to Dauki and
I have not specifically mentioned, Lordship. I have because I had.
what do you mean by not specifically mentioned?
Only
What is your version of the story?
Lordship,
When did you go to?
I have not mentioned the specific day. Only, Lordship, what I have mentioned is that on that particular day, I was in the market area.
That is okay, but then is it not relevant that we should know also when did you come to Dauki?
Of course,
when
it
did
is
you
not.
come to Dauki and how you came?
Because in the quashing, I did not mention it, Lordship. I thought perhaps.
But then that is needed.
Because
if you want to refute the prosecution version of the case, that was needed on your part, at least to mention in your petition.
Lordship, what I have mentioned is on that date I was well within the Dauki market looking for a vehicle, and that is when I have been randomly apprehended, Lordship.
That is all right. But then the thing is that the FIR says
Lordship,
that you have crossed over to Bangladesh, you stayed there for a few days, and then you came back.
And that is what the FIR.
Yes, so
that the
you have
allegation
not
is there.
you have not put any counter version of the story.
I have mentioned, Lordship, that is a false allegation. I have never gone to this and that.
Denying is one thing.
But explanation is not given because they had recorded my statement on the same thing. Now, if I came with a different.
When did you come to Dauki?
Lordship, Lordship, kindly. As from the instruction I'm saying, Lordship, Dauki I came on 1st July. Basically, I bought some fish and all, and then I left.
And when these.
That is what had happened. But it is not mentioned in the petition I fairly submit, Lordship.
You are on tourist visa, isn't it?
Tourist visa. One tourist and one is on medical visa.
Who is on tourist visa?
In first item, Lordship, item 2, Mehtabuddin. This is the tourist criminal petition 50, Lordship. Tourist visa. And I have got a type copy of that. This is, Lordship, tourist visa. This is the type copy. Lordship will see visa type T. So
Yes.
this is a tourist visa. And below also special endorsement tourist visa.
And what about the other?
The other item, Lordship, this was a medical visa. I have just typed it out also. This is MED1, Lordship.
Put some, or what is it?
When did you enter India?
Lordship. 25th March 2025.
Where it is mentioned?
In page 20, Lordship.
Of your petition?
Of the petition.
No, there is no averment in your petition with regard to that.
No.
You should have given the details at least.
Averment is...
So far as your version is concerned. Page 20 is the FIR, isn't it?
No, page 20 of the petition, Lordship, is the visa.
That is not visible properly.
The stamp is in between, it is mentioned, Lordship. The date, 25th March 2025.
Why you should have mentioned all those things in your petition?
That is, Lordship,
If you have entered into 25th March,
Lordship,
then you should have mentioned at least that from when to when you were staying in which place and at which place you have, when did you come to this side, when did you go to Dauki, how long you were in Dauki, was it not repaired? These are essential facts so far as your version of the case story is concerned.
Lordship, my only instruction is that it's not mentioned. I sincerely apologize. Only instruction is on for they were in Dauki only for that day only. They came in the morning. They were in the market.
Question is not of instruction. Question is what narration you have made.
It's not mentioned. That explanation is
how this court will get the facts of your version.
Because only the narration I see that, Lordship. There's some defect in the.
There is not
gap.
This is very, very difficult.
But only what is mentioned, Lordship, is that on first, after their marketing, they were looking for a vehicle and they were caught there, Lordship. Because till then, there was no adversity also. Of course, I should have explained it better, Lordship.
No, these are vital facts. In absence of that, to which way court to come? Even if court wants to draw a conclusion in your favor, how court will say all those things?
In that event, Lordship, I have to amend it. There's no option, or that was not explained here. It was only on the basis of the. I mean, what
You
was
are
it?
required. You are seeking quashing.
Lordship, yes. What is apparent, Lordship, is that he entered on 25th. That is there, but of course, it has not been explained in detail.
And then how do we know when you have come to this side? There's nothing in your petition. 25th March you have entered India.
Lordship, yes.
And then from 26th March, where you were? If you want to counter this allegation,
Lordship,
that you did not go to the Bangladesh, you did not go to Bangladesh,
Lordship,
then how, on what basis, on what fact you will say it? There's nothing, there is no factual assertions.
Factual is
so far as
only what
your
is
own
in-
location is concerned.
Lordship, that is correct, Lordship. I cannot. It has not been mentioned properly, Lordship.
So, but then in absence of that, in which way you expect us to decide then?
I have to, Lordship, amend this paragraph 6. There's not, the details are not mentioned.
I do not know what you do, but then how can that be?
What has been only mentioned is on 1st of July, they were, after the shopping, they were looking in the vehicle in and around the Dauki area and they were caught there, Lordship. I mean, apprehended there on the basis of suspicion.
You have come as tourist, isn't it?
Lordship, yes, as a tourist.
Now, so far as your movement is concerned,
Lordship,
it is not required to be tracked, isn't it? There is nothing that it should
Not, Lordship. Because there was no adversity till the time of my arrest. That
is all right. That is what okay. But then how do we know? How do we know that? How do the court knows that you have come to Dauki on such and such?
Of course, the dates
in
are-
absence of your assertion in the thing.
it is not, Lordship. It is only on instruction.
A factual statement. How much a lawyer submission can cover up?
I understand that. Lordship, what is there stated, Only my instruction, of course, it is not mentioned here, was that they came on first, they went to the market, they bought some fish and all.
See, on the basis of incomplete instruction, he could not have filed this petition.
Correct.
You should have said that on such and such day you have travelled to Turkey.
It was not mentioned, Lordship. That is the only. I mean, at this stage.
And on the same day, or maybe on the next day before you came back, then you were caught by them. Nothing as such in your petition.
Of course, Lordship, that in para 6 that has not been mentioned specifically. I bow down to that. So I have. What has been only mentioned is that on this day they were. But my instructions, they came on the same day and it all happened the same day. Before that, there was no such adversity at any point of time, Lordship.
In absence of all those relevant facts, this becomes very difficult for. You have not brought in enough material to counter the allegation made in the FIR.
Lordship, because in the, of course, Lordship, it should have been better explained. But in the FIR, Lordship, though, my only humble submission is in the FIR, they simply alleged that I was on that day only this has happened. It was not in the FIR that they came on so and so date or they crossed over on so and so date, came back on so and so date. Of course, Lordship, it was for me to explain.
There is an allegation that you crossed over, you
Correct,
stayed
Lordship.
there
It
for
was
2
for me
days
to
and you
explain.
come back.
Lordship, I.
So was it not required for you to counter it by giving your fact, your version of the fact?
Lordship, that is correct, Lordship. It has been.
Should have been basically in the more specific term.
Lordship, yes, they should have been para 6, Lordship. It is very vaguely mentioned. I completely agree.
Para 6, you said you have travelled to Meghalaya, and in such regard on 1/7/2025 you were in doubt.
Lordship, yes, that was the only. It should have been better explained, Lordship. I completely because.
You do not say when did you travel to Meghalaya, when did you enter Meghalaya.
Lordship, only my
you did not
instructions.
say how long you have been in Dauki.
Correct. I see that, Lordship. I see that. Only my instruction is that it all happened on the same day. That it was not specifically mentioned. I completely, Lordship. I completely agree to that, Lordship. And
even for the sake of reference also court cannot go, court would not know where you were. At least for the purpose of appreciating the entire fact.
it doesn't. I fairly say, Lordship, it has not been specifically mentioned. Only that it has been mentioned that they were apprehended on such and such date, and that the allegation of crossing over to Bangladesh is fabricated, Lordship, and they were apprehended from market itself at para 11, page 11. It is mentioned again vaguely, Lordship. I dates are not mentioned, Lordship. I see that, Lordship. Entering through the immigration, I have mentioned at para 14, but again, date
Nothing, there is nothing material.
It is not specifically mentioned, Lordship.
Only at paragraph 12 you say the allegation that you have crossed over to Bangladesh is entirely false.
Lordship, he was
Fabricated, and you do not bring your version of the story.
Lordship, that is.
So it's a kind of evasive denial.
Some details are, Lordship, I see, Lordship. And at para 14, may I kindly see again, of course, it's not specifically mentioned, Lordship.
Now, so far as your entry was on March 25th.
Lordship.
Till your whereabouts in India till 27.
Lordship is.
It is not known.
That is not. It is not.
It is not known to the court.
That is correct.
And then what do you expect from this court? Just tell us.
Only my humble submission is, Lordship, that the allegation that on the day of the FIR, that is where, Lordship, that has been explained.
You know at what stage you are exercising jurisdiction, to what extent you can go into
I
it.
understand, Lordship. That it should have been better explained.
So in absence of all those material aspects, what do you expect?
So then I have to, Lordship, file a additional.
No, but then again the time is very short.
Time is short, Lordship. I have to. But that did not, Lordship. It was my mistake, Lordship. Instruction was that they came on that very day. They went to the market. Of course, that is not. I am just. But it has not been detailed in the petition, Lordship, that I.
Not even a single line. From 25th March.
No, it is not there,
Till
Lordship.
1/7.
Correct. It's not there, Lordship.
So in such a situation, if anything is to be presumed, then where it will lie? Huh? Where it will go?
I have to, Lordship, file an affidavit by tomorrow. If that is the.
While by tomorrow, you see, like court cannot be like a machine, no? Just
I
hear it
understand.
and then.
I understand.
Court has to apply its mind to
I
its
understand.
thing.
I understand.
And when a thing which is basically contested, seriously contested,
I understand.
court has to.
Because for me also to explain, Lordship, because they in their charge sheet also that is not the issue in my humble submission. That I mean they also, it's completely silent. When did I go? When did I come? And so on. But it should have been. I should have explained my part.
What you say, it's all right. But
I
then,
completely agree, Lordship.
you see, then you leave it for this thing evidence. Then evidence will reveal it.
I completely agree, Lordship. What is falling from the court, that I should have explained that.
Court can very easily reject your petition saying that you do not have, you yourself were not brought into record, that where you were for this thing. It is March, April, May, more than 2 months.
2 months. That is, it has not been explained. That is the, I mean.
A non-disclosure can be a good ground for rejecting your case.
Dates are not mentioned, Lordship.
Forget about dates. You have not said your. See, we do not want that it should be stated very specifically, date to date wise and all those. See,
I understand, Lordship.
Nothing has been mentioned. Because you were here in India for few months now.
Correct, from 25th March, Lordship.
Yes. So in absence of your assertion, we cannot presume where you were. And then such a situation, facts alleged in the FIR will have to be proved.
So then I have to, Lordship, file an additional affidavit to bring into that.
How many additional evidence will you find?
Because what has been only mentioned in the petition is that on 1st of July they were in the market, and after the
My lord, his being in India on 1st of July itself is violation of visa condition, my lord. He entered on 25th March, my lord. Visa says permitted for single stay not exceeding 30 days. And this was the 4th month he was in India, my lord. So that in itself is violation. Secondly, my lord, there is a foreigners restricted areas order. Entire Meghalaya and Assam is a restricted area, my lord.
That is what exactly the very first day the court was putting that question. Because that was in the knowledge of the court that there was a restricted area permit in operation.
So there is a foreigners office we see in the DC in SP office, my lord. Every foreigner has to come and register there.
Exactly, that
No,
is what.
these are the order,
restricted
my
area
lord.
permit is for that. Then probably since there was no assertion by any of the parties, this court was under impression, probably that has been lifted.
No, it's still there, my lord.
That restricted area tag has been lifted.
And moreover, my lord, because of Bangladesh disturbance, 144 now it is a different provision in BNSS have been imposed on Indo-Bangla border from certain time to certain
okay.
time. So he is violating that also, my lord.
Now, see, mere 144 violation will not bring any charge under Foreigners Act, isn't it?
Yes, ma'am. So that's
we are on the broader thing. We are not going into any other things which you say now.
Am I seeking quashing of the FIR, my lord? He has to establish with maybe if I can give an example, my lord, if he has a bus ticket that he went to Dauki on the same day and he returned on the day, or he was trying to come back on the same day, he has to bring positive evidence, my lord.
At least there has to be an assertion. Whether evidence is there or not, that we will see. In such a case, then at least court will have some material to see whether your FIR is apparently false. Otherwise, you know,
And
in
10:30
absence of that, that is
and
what
timing,
problem.
lords, you kindly see the timing, 10:30 at night, my lord. Dauki is just a deserted place at 10:30 night. This is a, like
Anyway, that we do not know. That we do not know. It may happen like that the tourist may suffer many things. Now, one thing is undeniable is Dauki is a tourist spot. It is frequented by visitors. That is what, if you go also, you will see it.
But 10:30 night.
That is, you may have
My
a
lord,
tourist.
these are only presumptive, my lord.
He may go with a vehicle which may have a breakdown. He may have to look for some other things. There may be many things.
But he has to make out a
But then
case.
the only thing is
He has to say that.
exactly-
He has to say that his vehicle broke down or
Exactly,
something,
Dr.
something.
Monica. That is what. That
He
is
is
what.
not saying anything, my lord.
It doesn't say.
If he says that he's
Just an
brave,
assertion
my lord,
that you
or he was kidnapped and something, like some story has to be there.
Just a assertion that your allegation is false in the FIR,
yes.
but then without any counter version.
Anything, my lord.
Of course, the criminal law doesn't define it, but in CPC there is a definition what is evasive denial, what is specific denial of this.
But
Some
you-
material is needed.
The criminal matter denial will not do, my lord. He has to counter that.
Now again, just rejecting this petition on basis of no mention of this also, this court, you say like, may have feelings that this was not been properly adjudicated. You say like court wanted to properly adjudicate the matter, but then in absence of those facts, so which way it can?
But now additional affidavit, he'll simply make a statement that I went to.
See, there may be an option to withdraw this petition with the liberty to file afresh, but then we do not know. Like,
Well, visa, I don't think if this honorable court passes an order to renew the visa, the government will have to do that.
is it required? I think because it was pointed out earlier by Madam Sharing about that 1948 order.
Yes.
There is a provision, I think, so far as the permission of departure when a person is facing criminal charges. So this is a criminal charge.
Well,
So probably that will stand automatically extended. Because until and unless he is exonerated from the charges made, he cannot leave the country.
he cannot leave the country.
Paragraph 5(2)(b) says that.
Yes,
For
yes.
the foreigners ordinance.
Yes, you referred to it in the. Now the only thing is that we do not know, say like whether
I completely, Lordship.
Your Lordship is right. All these days, where was he? What was he doing?
At least court should have, you see, court should have it in mind, you see, before court applies. You see. Some factual assertion should be there in the petition
And this is a
to
single
allow the
entry
court
visa also.
to apply its mind. Otherwise, court has to blindly believe what is there in the FIR. Because we are exercising 482 jurisdiction, isn't it?
And what seems more logical, my lord, he is a Bangladeshi national originally. He is on asylum to UK. His passport says that he can travel to any country in the world except Bangladesh.
Yes, that we have.
So because he cannot go to Bangladesh, what he does, he comes to India. That is very, it's very,
that is
the
assumption.
story is
See,
in place, my lord.
We see, one can understand it. Okay, without maybe referring to the things, but then we are bound by the materials on record. So even if we assume that, even if we strongly assume that, that cannot be a basis for deciding that. That is why court was looking for factual assertion by him.
And from their position, my lord, Bangladeshi taka is found, my lord. If a person is coming,
how much? What is the quantity?
Value is not much, my lord. But if someone coming from UK, my lord, who is in asylum for 20 years,
Have you traveled to a border area?
No, my lord, he's coming.
Maybe you are, of course, this personalized court knows that you are from Siliguri.
He is coming from UK,
proceed
my
a
lord.
bit further to Nepal border, you will find there are areas where Indian currency and Nepal currency both works.
Well, Nepal, Bhutan, Indian currency is working, my lord.
Anyway,
No one
like
to
normal
find
cases, if a tourist stays in Dauki, and if he has something, say like a very small amount in possession of Bangladesh currency,
20
that
taka
by itself may not be a doubt. You may not create a doubt that he has crossed over. Okay, but then the thing is that the problem is that there is no assertion by him.
And to quash, my lord, he has to meet those parameters. He has to prove his case to that standard, then only this honorable court, my lord, will interfere in that.
I have to.
There was a bus ticket also of Bangladesh. He was traveling from Sylhet to.
There's a bus ticket also.
That is also has been seized.
It was in his pocket.
Mr. Dev, you will
That
have
is not there. I don't see it, Lordship.
Page 3.
Sorry, this court was
In our affidavit,
basically initially it was with you. Court also
Regarding the assertion, Lordship, I
did not
see
want
it
that
was.
a tourist should be harassed just
Perhaps,
because of his Bangladeshi originality and that Dr. Mojika said about that
Going
by
from
applying
the-
that strong presumption that since you are barred, definitely there is a likelihood you will do it.
Lordship, that perhaps, but what I'm saying is, Lordship, only with regard to that part, of course, I completely agree, Lordship, it should have been better explained. If I may be allowed to add.
That becomes fatal for your case. No?
I appreciate that, Lordship. I see that, Lordship, because this has been mentioned in a very vague terms that.
There's
he
no
has
interim
not
order.
crossed over
They can withdraw and file a fresh one, my lord, rather than amending this presumption.
Provided he makes that prayer, then maybe we can.
There's no interim order, so
And this
they can
bus
do that.
ticket is dated 26 June 2025 from Sylhet to Mymensingh.
Yes, madam. This all will be with matter of evidence. You see.
Yes, so that is why he has to face trial, Your Lordship. At this stage, you should not wait for caution, Your Lordship. Then only we can be able to come to a fair conclusion.
Yes. What is to be done?
Lordship, if I may be allowed to file an additional affidavit by tomorrow, Lordship.
Additional affidavit will make these things, especially factual assertion.
Lordship, that is because at this stage, even if I make that assertion, it will come back to the same position, Lordship, with my humble submission. Because what apart from that part, what remains is, Lordship, the entire charge sheet is based on my own
this
statement.
matter has been heard for a considerable length.
Lordship, yes.
Thereafter, just to correct those loopholes, you have to come with this additional affidavit.
Correct. That is why I'm saying, Lordship, even if I
That
withdraw
doesn't
and file a
fair
fresh.
to the other side.
I appreciate it, Lordship, because even if I withdraw and file a fresh and just add another paragraph, that would come back to the same
That
thing.
you know what you to do, but then the thing is that see, like your petition suffers from deficiency. That is what this court can say.
I see that, Lordship. I see that.
Now, which way you cover up the deficiencies of
Lordship. Because the fact remains that now a charge sheet has been filed, Lordship. And that charge sheet is, in my humble submission, without any material. It is admittedly based on my own statement. So, position remains the same, Lordship. At the end of the day, whether the charge sheet is liable to be quashed, Lordship, perhaps would not depend on. Perhaps, Lordship, would not depend
There
on
are
my
many other aspects you see, like if this comes out at this stage, it may sound to you as if that the court is standing as other side counsel. So, but then there are many things. You see, So that is where, anyway, it's up to you. But then we will not allow you to file any additional affidavit. We will decide it on the basis of this, what you say.
Lordship. Because for me to withdraw and file afresh, it will come back to the same thing in my humble submission, Lordship.
Then we will not allow you to file any additional affidavit. There is no question. Yes, Dr. Mojiga, you were pointing out something.
Well, so, my lord, there is a foreigners restricted areas order. I'll just place it. Take this also.
Will it result in violation of
14A.
14A? But then your FIR doesn't say so. No allegation. Your charge sheet also doesn't say so.
But there is lots of kindly
Now,
see.
is it not that it got superseded by that 1948 order? Oh no, no.
This is 63, my lord. And this is amended as late as 1990, my lord. So, my lord, you kindly see. Well, first I wanted to point out the visa, my lord. Visa says, except for restricted area, they've given the printout, the typed copy, my lord. You also kindly see in that.
Yes, permitted for single transactions,
Single-
not valid for prohibited, restricted, and cantonment areas.
cantonment areas.
Yes.
So what is the now restricted areas, my lord? There is a separate order for that. Lots of kindly sees definition 2B, my lord.
Just a minute. Yes, restricted area.
Restricted means any of the areas specified in Schedule 1. And then, my lord, if lots of kindly turns to next page, Schedule 1 is mentioned, my lord. Every district in the state of Assam,
Yes.
every district in the state of Meghalaya, northern district of West Bengal, Tripura, Andaman Nicobar, and Sikkim, my lord.
So this stands as understood.
This
There is no modification or amendment of this.
But this is what I understand, well, this is as it is, including the amendment as well.
That is what you have to tell the court. So
Right.
that means like there is no further amendment to it, isn't it?
As far as I
No
could
area
gather,
has
my lord,
been included or excluded from there.
that's what I understand, my lord.
Okay. So any violation of this will constitute an offence under 14A.
My lord, if I may take you lordship to 14A also, my lord, once of that. And my lord, the charges, as a charge sheet has just been filed, charges can always be modified by the court also. So I'm just pointing out that there are offences committed by him.
Exactly. That is what the thing is. So that your submission will be that. Your submissions will be that. Your submission will be that. That even if his entry is as per law, so far as the country is concerned, he is busy to this side. Keeping apart that allegation, he crossed over to Bangladesh.
Even if
he
it
is
is-
busy to that side,
Even
will
it did not-
constitute an offence under 14A.
14A, my lord. And plus violation of the 30-day conditions will constitute another violation, my lord, that will fall in some other section, my lord. That will come under section 14, my lord. What is 14?
Section 14.
14. 14A,
Yes,
penalty for contravention of provision.
Yes,
Whoever remains in area
Just a
in-
minute. This court has got to the wrong thing. Yes.
remains in any area in India for a period exceeding the period for which the visa was issued to him, does any act in violation of the conditions of the valid visa issued to him for his entry and stay in India or any part thereof. So, well, clearly is violating both A and B also. Then coming to 14A, my lord. (14) capital A is B, my lord. enters into or stays in any area in India without the valid documents required for such entry or for such stay, as the case may be under the provisions of any order made under this Act or any direction given in pursuance thereof.
Okay. So there is a yes. So it means like whether it constitutes a charge under 14 small a or 14 capital A. See, capital A charge is coming out. See, because this is entry. If you see that restricting a party, so
So these 2 points legally, my lord, and third thing that coming to the pleading, there is no averment, my lord. There is no positive evidence. That's third aspect, my lord. And fourth aspect that on information at 10:30 in Dauki, my lord, and with Bangladeshi taka and as the day is submitted, there is a Bangladesh bus ticket also, my lord. So taking all these into consideration, my lord, in my motion is not a case for questioning, my lord. He has to face trial, my lord.
what about the second petitioner? The second one, 51.
The second one, my lord, is a medical visa, and
the same RAP applies, restricted area applies.
Yes, ma'am.
So your submission will be same more or less.
More or less same. His only date of entry is 5th June 25, my lord. He entered India on 5th June.
And the expired is of November.
Okay, he has a longer period.
Longer period.
He still has time, my lord.
Because of his medical visa.
He also entered through Delhi.
Delhi, my lord.
On 5th June. They did not come together.
His date of entry is
5th June 25. And visa is valid from 3rd June 25 till 2nd December 25. 3rd June.
But then you see, like
the 30 days.
Single stay is not to be
more than 30 days valid.
So what does it mean? Means if a person has a visa for 3 months, and if he has to stay for more than 30 days, that means he will have to go back.
Go back, well.
Again come back.
Well, there are two types of visa. If I may just simplify the, my lord, to country like US and all, they give 10 years tourist visa, my lord. So in that 10 years, they can go 20 times and come back, but they cannot stay in one go for more than 6 months. So before completing 6 months, they have to come back to India.
Visa is granted by which country? The country which he is visiting or?
India.
Visiting country.
Visiting
Here,
country.
India
That
is a
means the
visiting
stipulation will be made by the condition will be made by India, isn't it?
Yes. In this
not
case,
by things. He may hold American passport, but then visa
no,
will be by.
my lord, what I'm saying, if Indian wants to visit America, my lord, then he has to get a visa from America. Now, different countries give different types of visa, my lord. America gives for 10 years, India gives for 6 months only, at once. So this is periodic visa, my lord. Second type of visa is that if you go to Singapore, my lord, you have to mention that which date you are arriving, which date you are leaving. It's a one-time visa only. So supposing I'm going from 5th December to 10th December, I have to mention in the visa that I'll enter Singapore on 5th December, I'll leave Singapore on 10th December or 15th December.
Once you leave, then the visa loses
over.
operation. But then here, it remains valid for 6 months.
My lord, this is valid for 6 months.
But then one visit has to
30
be
days he
less
has
than
to go
30
back.
days.
30 days he has to go back.
He can go back, then he can come back again.
And second, then it says second visit cannot be within 2 months. There is another clause there. It says, my lord, there should be a gap of 2 months before successive visits.
So validity of visa for 6 months would not give you a right to stay for 6 months.
No, my lord.
It is much lesser than that. If there's 2 months gap, is to be maintained.
But this is only so that he doesn't have to apply again, my lord. He wants to come twice, thrice.
Okay, Mr. Dev, now what will you say?
Lordship, my humble submission is confined to the charge sheet itself.
That we You have already said.
My
What you will say about section 216 CRPC?
Lordship, please.
As has been submitted by Dr. Mojika, that charts can be altered.
Lordship, charge can be altered, but here
Thing is that whether the FIR discloses an offence or not. That is what matters.
Correct. Well, I have only very limited submission, Lordship, on this. Whether the FIR discloses an offence and whether the investigation collected in pursuance to that FIR, which has led to filing of a charge sheet, has sufficient evidence to disclose an offence. As per the judgment
According to you, there is no prima facie material for proceeding with the trial.
Lordship, they have lodged an FIR. No one could have stopped them from lodging an FIR, Lordship. Even if it is on purely suspicion, they have entitled to do so. They have done it, Lordship. And now a charge sheet has been filed pursuant to a full-fledged investigation. There is no prayer by the IO to file an additional or a supplementary or anything of that sort. Lordship, a specific charge has been levelled against me, for which I am required to face the trial. That I have illegally entered Bangladesh from the unfenced border. And that, Lordship, now they are saying that there is bus ticket and this and that. Nothing is there in the charge sheet, Lordship.
Okay. So even the list of documents which has been...
It is not there, Lordship. And
appended with the charge sheet, there is nothing.
Yes,
nothing.
and now, Lordship, what they do, admittedly, the entire charge sheet is based on 13 documents, Lordship, 2 of which are my own statements, 3 seizure lists. Kindly see, Lordship, the charge sheet in the affidavit filed by the state itself, page 14.
The second document you have submitted is with regard to 144, section 144.
Yes. Page 13, Lordship, of the additional affidavit filed by the state.
Page 14 of the additional affidavit,
Lordship,
not your.
It is the same charge sheet, but I'll just rely on theirs. Page 14 of the additional affidavit filed by them.
It is not there in your petition. Is it there?
It is there in my additional affidavit, Lordship, the charge sheet. This is, Lordship, additional affidavit filed by the state on Friday.
Yes, page 14.
Page 14, Lordship.
Yes.
Lordship, this is the
statement of the petitioners in both the cases. First two.
Lordship, first two. Second two are certificates under section 63 with regard to the seizure of the mobile phone, like earlier in the 65 of Evidence Act. That, Lordship. 5, 6 and 7 are seizure lists.
No, seizure list.
Lordship.
No, this seizure list pertains to what? Seizure of what
Yes,
material?
I'll take Lordships to the seizure list also. Lordship, kindly see page 19. This is what has been seized from the person's, Lordship. Page 19, this is the first seizure list. Description of items: UK pass travel document, driving license, residential permit, ID, currency, mobile phone, personal belongings. This is one seizure list, Lordship, where there is a mention of 20
Bangladeshi taka is very negligible.
20
Huh?
rupees, Lordship.
Only 20 rupees.
20
taka.
1 10 rupee and 2 5 rupees. 220 rupees of Indian.
This is fast. And the second one,
And in the next page, Lordship, page 20, for the second accused, here
Yes.
also, UK national document, residential permit, iPhone so and so, currency Indian rupees 800, and personal belongings.
Okay.
And page 21 is the third seizure list with regard to the some pen drive or something, Lordship.
Nowhere mention of any bus ticket and all.
Lordship. Now, again coming back to page 14, Lordship, will see. So this is 5, 6 and 7. Then, Lordship, 8 is photocopy of the Bangladeshi ID.
Yes.
9 is photocopy of Bangladeshi passport. 10 photocopy of Bangladeshi passport.
Name of Ziaur Rahman. Who is Ziaur Rahman?
He is the second accused, Lordship. The second accused.
How you are related to second accused?
They are not related at all, Lordship. Not related.
But then that has been found from the possession of? Okay.
From individually, Lordship. Individually.
Okay.
So what has essentially happened, 8 to 13, 13 is photographs of the accused. These are, Lordship, these were seized from the accused possession only. But surprisingly, while the Bangladeshi documents have been separately enclosed, the UK documents have not been separately enclosed, be that as it may, Lordship. But seized in the same seizure list.
That is not separately specifically mentioned here.
Not specifically mentioned, only seizure list is mentioned. So in my humble submission, Lordship, that even in the charge sheet, if Lordship will please to see page 13 also, the narration of the facts by the prosecution, there is no mention of any version of the complainant or any witness or that specific information which they are talking about, that they got a specific information or anything, Lordship. And it is not their allegation that I have violated the restricted areas order, or that I have violated the visa condition or otherwise, Lordship.
There it refers to specific information.
Yes. No, but what is that information is not come out. That is only what I am saying, Lordship.
What you will say about the restricted permit, RAP?
Lordship, my humble submission is, Lordship, that of course it is not mentioned anywhere, and I also, whether they got that permit or not, because that is not the allegation against them, Lordship. That they did not get the RAP or anything of that sort.
Allegation is that you see, like you are suspected for foreigners that you have been.
Allegation is I have come from India to Bangladesh illegally through the unfenced border. It is not a case that I have entered the restricted area or that my entry into Meghalaya only was violation of 14A. Because perhaps, Lordship, RAP was there, I don't know, it's not mentioned here. But that was not the case of the prosecution, Lordship. That I have not got the permit or the some special permit for this. Because had that been the case, then I would have probably been arrested at the very entry, Lordship, or into Meghalaya. Or even Assam, because even Assam is part of the...
That is what, you see, like if, that is what some monitoring is needed, so far as the foreigners are concerned.
Correct, on an
Because
administrative
otherwise
level.
how their movement will be checked.
Correct. On an usually what I know, Lordship, is that they get a permit from the SP or some magistrate. But in any event, that was not at all the allegation, Lordship. Now to completely change the charge under 216, that from changing it to entering in Bangladesh, India through Bangladesh, and to change it suddenly that you have entered Assam or Meghalaya, which is a restricted area, Lordship, that may not be covered under 216, Lordship. And the investigation would have revealed, Lordship, that had there been a violation of that aspect.
Dr. Monchiga, what about this order 3?
Is that?
Come to the proviso to clause B of order 3. It will be second page of your thing. Provided also that a foreigner shall not be required to obtain a permit order. You got it?
In respect of any place or area falling within the restricted area, a visa granted to him in pursuance of the Indian passport was made specifically valid for. His visa doesn't say anything, my lord. His visa rather says that he cannot travel to restricted area, cantonment area.
Or rather it puts a bar.
Puts a bar.
Okay.
Lordship, my humble submission is with regard to that restricted area orders violation. That is not the case, Lordship, of the prosecution. At all. That was never the charge against me. That was not the FIR also against me, Lordship.
That is all right. There is one to say to look into it. But then what happens if the allegation in the FIR is accepted? Whether it will make out an offence against you?
For restricted area permit, that allegation is not there.
Without disputing the allegations.
Lordship.
We assume that whatever allegation is made is correct.
Correct.
Whether it will make out an offence or not.
Lordship, it does. If Lordship only sees the FIR, an offence is made out. But only what I am submitting.
Then you know law very well.
Lordship, if Lordship will see the third, in Bhajanlal's case only, Lordship, I am not going beyond that. That if there is no evidence collected in the investigation to make out an offence, Lordship, that is a good ground for quashing, Lordship. And in my humble submission, a charge sheet under Foreigners Act for whatever offence, 14A, B, whatever offence, Lordship, cannot only be based on my own statement recorded by the police, Lordship, without any other material to indicate that there is a violation, Lordship. And that something, Lordship, to show that someone had seen or someone had known, nothing is there in the
You have
charge
said all those things before.
Lordship, yes. So only my only humble submission is, Lordship, this charge sheet in my humble submission is liable to be quashed because there is no material supporting it, Lordship.
Okay. Well, pass order. Just send it. We'll see if we can pass today, or maybe I'll keep it reserved also. I don't know. Just let us. Yes.
Obliged.
Lordship, in support of my contention, I'm giving some of
You had given some decisions. These are already there.
It's already there. There are two more, Lordship.
On what point? Specifically on Foreigners Act?
Not
Or on the brief process? That's okay. You leave it. See, it is already there.
Can weigh the evidence and all that. And if there is any suspicion also, then the case can be.
See, madam, the law is that if FIR plain reading of the FIR makes out an offence,
Makes an offence, Your Lordship.
that is good enough. Whether that will be proved or not proved, that is not the consideration at this.
That cannot be considered by this order.
Yes.
That is to be left out.
Obliged.
Item number 10.